individual lawyers. Youngest Business World Legal 40 under featured in Fortune 500 magazine special issue for authoring bestseller book on the rise published by Universal Law Publishing, an imprint of LexisNexis. Sir is recognized as an arbiter expert by SCC Online, qualified in the conference round for Judge Advocate Journal in Indian Army. Skilled in international and domestic arbitration, MSME disputes, writs, commercial, employment, insolvency, and bankrupt laws handle arbitration under Singapore International Arbitration Center rules, International Chamber of Conference rules, Delhi International Arbitration Center rules, Indian Council of Arbitration rules, etc. Sir is experienced in handling arbitration-related litigations like appointment of arbiters, injunction, interim relief, etc. in various courts of India. Frequently invited to speak in various law conferences in events by domestic bar associations, law schools, alternative dispute resolution centers amongst the organization. Sir have more than 50 publications to my credit in various journals, magazine, and proper legal news portal. So just a little housekeeping before we get started. If you have any question during the session, please type them into the chat box. We will only be keeping question towards the end of the session. Now, without any further ado, I would like to invite Advocate Tariq Khan sir to share his valuable knowledge on international perspective of arbitration. Over to you, sir.
Thank you very much for a lovely introduction. And thank you for this excellent initiative and for making me a part of this workshop on arbitration. This bootcamp, I was very happy to see the brochure when I saw such eminent speakers. And it was indeed a privilege for me to be a part of this excellent line of speakers. So thank you for considering me at the outset. The topic which has been chosen today for me to speak is world versus arbitration, in the sense that I am supposed to speak today on the international perspective of arbitration. I would like to start by telling you the origin, and I would like to start from, I'll take a step back, and I'll tell you where arbitration came into the picture. So I will be emphasizing slightly little bit on the evolution of arbitration internationally and from where we can trace it. Ordinarily, it is not possible to trace the history of international arbitration and to say with confidence and certainty as to when it actually started. But the issue that we have seen is that whenever an attempt has been made to find the history or origin of arbitration, then we have been lost in obscurity because we do not know as to when it actually started. But I'll tell you the closest incidence that has been cited often is the biblical theory. So in Bible, that very famous incident of King Solomon, you may all have heard of it, but I'll just remind you, probably it's a childhood story that we used to hear about justice and law. In that case, what we have heard is that there were two women who were fighting over a baby. And so the one woman said that this is my baby, the other said, no, it's my baby. So the matter was brought before King Solomon, who then said, okay, I will decide it. We will cut it into two pieces and we will give both of you one part of the baby. So one woman said, yes, this is absolutely acceptable to me. And I'm very much inclined to go ahead with this proposition. And she in fact agreed with this decision of King Solomon. However, the real mother of the baby started crying and said, no, please don't do that. Let this woman take the baby. So then immediately King Solomon understood that the real mother wants the baby to be cut in two pieces. So that is considered to be one of the first few incidents where arbitration internationally was accepted. And they say that the method which was adopted by King Solomon at that relevant time was just like arbitration that we do today. So this was one of the first few incidents, but I would like to quote the only female founder of American Arbitration Association, Frances Keller, who in her book, American Arbitration, Its History, Function, and Origin, has put it very pithily, and I would like to quote her. Of all mankind's adventures in search of peace and justice, arbitration is amongst the earliest. Long before laws were established or courts were organized, or judges formulated principles of law, men had resorted to arbitration for the resolving of discord, the adjustment of differences, and the settlement of the disputes. The father of Alexander the Great, Philip II, is also considered to be one of the arbitrator, interestingly. And there was a dispute, territorial dispute in Greece as back as 337 BC. And that is when it was said that arbitration has been in existence till then. But if I give you an example of the Olympians, the Greek gods, there was a very interesting incident which I'd like to mention here. So basically, there was a marriage, a Greek wedding. And in that Greek wedding, there was a dispute between three goddesses, the goddesses of Olympus, Aphrodite, Hera, and Athena. So all three of them had to decide in a competition that who is the prettiest of all. Now this dispute arose. Zeus asked Hades to take these three goddesses to a shepherd called Paris. And when he went there, so all three goddesses started offering him something or the other. So Hera said that I will make you the richest of all. Athena said that I will probably make you the king. And Aphrodite said that I will get you married to Helen. Helen was considered to be the prettiest woman in Greece. So eventually he agreed with the reasoning and with the deal that was cracked between him and Aphrodite. And he said that she is the winner. And then you must have seen that movie Troy, wherein due to Helen, there was a proper war of Troy. There was a Trojan horse and fall of the city Troy. So anyway, without getting much into this, what I'm trying to explain is that arbitration internationally has a long history. And as back as, if you go back to Greek gods, you will find arbitration there. If you go to, there was a dispute between the island of Salamis, between Greece and some other country. And that was also decided by 5 Spartan arbitrators. Those were judges. So all I'm saying is that international arbitration is not something, like Indian arbitration scenario, which started not as long as arbitration internationally. But what led to the growth of arbitration worldwide and how it gained popularity in each and every country? I think I would like to give credit personally to the New York Convention of 1958. More than 150 nations are signatory to it. They honor and obey the awards which are given in one country or one state, and they enforce it in their state. So I think that's the beauty about arbitration. Another reason why arbitration gained popularity internationally is BITs. And I think that BITs, 1796, I'd like to tell you something about BITs also. So basically, BIT is a bilateral investment treaty. There's a host country and which is inviting or attracting investments from different countries. And if anybody who's interested in making investments in that host country, they would like to make those investments via BIT and not directly. Now, what is the reason? Why would anybody choose to invest billions of dollars in a country via bilateral investment treaty and not directly? So the reason is simple, that BITs are negotiated between two nations, two states, that if my country people are going to invest in your jurisdiction, these are the benefits that they will be getting, and they will get fair and equitable treatment. There'll be no discrimination with my investors, and that there are various clauses which are given, various benefits which are given to investors when they invest via BIT. So that is one reason BIT led to a lot of investment in various jurisdictions, and especially in today's world. And after the economic liberation in, I think, 1991 or so, when we saw that globalization has been increasing tremendously since then. So investor-state disputes are on the rise. And there are a lot of investors who are facing issues in different jurisdictions because they just do not get their money back. Because at the end of the day, if anybody is trying to do some business and investing billions of dollars in your country or state, what they expect is that tomorrow, if disputes arise between the parties, then they will easily be able to recover their money. Because if you look from the commercial angle or commercial aspect, nobody's interest is to get their money stuck in the court of law forever. And you know how the scenario is in courts, that once a matter goes to the court, it may take forever to be decided, or probably 10 years, 15 years. And by that time, the amount which is involved in the dispute, which sometimes runs into billions of dollars, is stuck and cannot be used in business. So that is the reason why MNCs and corporations or investors always want countries which are arbitration friendly and which are in fact looking at providing a very comfortable and convenient environment to the investors who are investing in that country. Now let's talk about India, for instance. We started pretty early. We were earlier than Singapore and other countries. Singapore, I think, somewhere in 1970s or 80s, joined the New York Convention. And India did it like 20 years before that, somewhere in 1962 or so. So India was one of the first few countries that signed the New York Convention. But still, if we look at Singapore, Singapore has become the hub of arbitration already. It's a famous choice of seat for arbitrations internationally. And if you look at Malaysia, Dubai, all of them are doing very well. And they're all trying to become the hub of arbitration. They're trying to be the best. Now, what is the reason why everybody wants to be a hub of arbitration? The answer is simple, that if you are a hub of arbitration, and if you're providing a robust arbitration mechanism in your country, then investors will be attracted to you and they will invest in your jurisdiction. And it will generate a lot of money for your country, for your economy. And that is the reason every country wants investments at the end of the day, because that's how they, the FDI, more the FDI, the economy gets better. You get more foreign currency, for more money. So all I'm trying to say is that becoming a hub of arbitration is directly linked to investments. And if you're getting investments, then you will become a hub of arbitration automatically, because a lot of investors globally, worldwide, are looking at you as a good prospective jurisdiction to invest money and to do business. Now, the Honorable Prime Minister has said that government has no business being in business. But the problem, unfortunately, is that a lot of time, often we have seen that the courts have been passing certain judgments which actually leave a very negative and which shows a very regressive approach of the Indian courts. And I'm sure that recently the trend has changed and we have, in fact, delivered some very good judgments also. But if you look at judgments like Vodafone, so what happened in Vodafone? Vodafone invested money in India. And you remember that transaction of 2008 or so, which happened in Cayman Islands. And the Indian tax authorities taxed them. Now, after taxing them, the matter went to Bombay High Court because Vodafone said this demand notice is bad. There's no capital gains here, and we will not be paying this tax of 5,000 or so crores. I don't remember the exact amount. Now, in the Bombay High Court, Vodafone lost. Then Vodafone went to the Supreme Court, and Supreme Court passed a very good judgment in favor of Vodafone and said that nothing happened, no transaction happened in India, therefore it will not be taxable. Now, ordinarily, when a party wins a case from the Supreme Court, it's over. The dispute is over. But unfortunately, in the case of Vodafone, that was not the case. The then finance minister, late Shri Pranab Mukherjee, he brought an amendment to the Finance Act that the taxing authorities can tax retrospectively. So in spite of winning the matter from the Supreme Court, the tax demand was placed back on Vodafone. And that's why the Vodafone invoked the India-Netherlands BIT. And then the arbitration happened. And recently, you may have seen in the news that India lost the bilateral investment treaty arbitration. And I think the India's nominee also ruled against India. So it was a majority decision that Vodafone was justified and India's tax demands were unjustified. Now, if you take such steps, if the government or legislature will take such steps, then the impression that we are giving internationally is that India is not a arbitration-friendly jurisdiction, and we will interfere with business of investors. And that's why the investors get a very negative signal from jurisdictions which are in fact not adopting a pro-enforcement approach. Now, other countries, if you look at US, for instance, US, UK, Germany, these are considered to be good arbitration jurisdictions, Singapore, Dubai, because they have honored arbitration agreements. So there are times when we have seen that the courts of a particular country, they resist arbitration. Like, issues like if there is a challenge to the arbitration clause, or, if then there's a question of judicial intervention. So in some judgments, we have seen that there is more court interference. And that is what arbitration is not about. If you want to show you are a good enforcement jurisdiction, or you are a pro-arbitration jurisdiction, what US, UK, and these countries have done to show that they are going to stick to arbitration and they want to encourage arbitration, they have accepted arbitration agreements. They have passed those judgments wherein they have recognized and enforced arbitration agreements. And they have rejected those kind of objections that there is no arbitration clause between the parties, etc. Those technicalities the courts have not gone into. Now, these kind of jurisdictions attract more and more investments because investors feel that their money is safe in these jurisdictions. Because if tomorrow disputes will happen, we will not be facing technical problems regarding arbitration clause being defective, etc., etc. The courts are going to give a favorable judgment in favor of arbitration, and they are going to encourage and make it expeditious. And the matter will not be stuck in court for years and ages. So that is something which the investors want when they're investing that kind of money. Now, another example I would like to give you is the reason why Singapore became popular hub of arbitration in such a short span. And if you look at SIAC, Singapore International Arbitration Center, I think in the past 10 years, it has grown 200 or 300%. The reason is, and if you look at the centers in India, we are still behind. So infrastructure is not what we need. I think any institution and any jurisdiction requires proper, robust arbitration mechanism and not a five-star infrastructure to become the hub of arbitration. I was giving you an example of Singapore. The praise and the reason why Singapore has become popular choice is because the courts of Singapore, the Supreme Court of Singapore, has enforced arbitration agreements, and it has not set aside foreign awards. It has enforced the foreign awards. Now, this is another problem. First is regarding the arbitration agreement, which I have told you. Now, the other issue is regarding enforcement. Now, what happens when a party wins an arbitration? Suppose there is a dispute between an Indian party and a foreign party based in Russia. Now, the Russian party gets an award in its favor, and it wants to enforce that award, to execute that award, and to recover the money, to enjoy the fruits of the award. Now, that party, Russian party, will come with the award to India because my assets are in India and they want those assets. And when they file an enforcement in the concerned High Court or Supreme Court, they see that Indian courts are not ready to enforce it. On what ground? Because there is only one ground of challenge, which is public policy, which has been a matter of dispute for the longest time. How the courts of the country have interpreted the term public policy. Now, if you look at the New York Convention, Article 5(2)(b) says that award cannot be enforced if it is against the public policy of the state. Jurisdictions like US, Germany, UK, Canada, France, we have seen them construing public policy very narrowly. The definition of the term public policy has been interpreted very narrowly. However, in India, initially when we started, we were in a very bad shape. Judgments like ONGC Sawpipes and Western Gigo, they further expanded the scope of public policy and made it so expansive so as to include everything in public policy. Now, what was the problem? Whenever an award would come, a foreign award would come to India for enforcement, the party against which the award was passed would take an objection that this is against the public policy of India and such an award cannot be enforced. As a result, the decree holder, the award holder, who was a foreign party, would lose the money. There'll be no point of getting an award because the Indian courts would not enforce it. But fortunately, the scenario has changed now. We are seeing good judgments like Vedanta versus Union of India, wherein the Supreme Court enforced the foreign awards. So there are, the judiciary is trying its best to make India and to give an impression that we are a pro-enforcement country or a jurisdiction. So every country has to give that impression to get investments and to encourage arbitrations. We have seen in other countries like UK, for instance, and US, I have seen there are issues regarding arbitrability, that what is arbitrable and what is not arbitrable. So the idea should always be to give an impression that we are expanding the arbitration scope and we are not treating arbitration as an ADR. Now, whenever I have heard in every lecture, in every article, in every book, and every student feels that ADR means alternative dispute resolution. Now, I feel it's high time we don't treat arbitration as an alternative dispute resolution, because I think alternative would perhaps give an impression that where parties have a choice, they have a negotiation, they can refuse something which is not binding, something which is like mediation or conciliation. I personally feel that arbitration is more than that, because arbitration is binding and you cannot wriggle out of your obligations. Because once you step in the arbitration clause and you say, I want to resolve my disputes by arbitration, now you are bound by it. Tomorrow you can't resist arbitrations and find excuses. So it is more like an amicable dispute resolution. And I feel that it is, there are various reasons why it has gained popularity in comparison to litigation. I'll tell you a few reasons why arbitration became international and gained popularity internationally. So one thing I've explained you is the New York Convention, to which more than 150 nations are signatory. And the other reason I have told you is that every country wants to become a hub of arbitration because it is the most popular choice of dispute resolution in investor-state disputes. And what are the reasons that I will just specify? And the other reason is that every jurisdiction wants to attract investments, which is possible only when you have a robust arbitration mechanism in your country. Now, let's look at the first reason, which I told you is, of course, enforceability. The reason why arbitration became international and gained popularity. So imagine if you get a judgment from a court of law, you cannot enforce that judgment in more than 150 countries. Whereas if you get an arbitral award in your favor, you can enforce it in more than 150 jurisdictions that have signed the New York Convention. So enforcing your awards, that is one important reason why arbitration is chosen as a dispute resolution mechanism. Another reason is neutral forum. Now imagine if there is a dispute between me, that is an Indian party, and a party which is a French party, somebody from France. Now, if there is a dispute, that party that has invested money in India from France would not want Indian courts to adjudicate, because generally they do not want the host state to be in control, because they are always of the view that we may have a disadvantage. So they want a neutral forum where their disputes can be resolved and where no party is having any kind of influence. And that is the reason why arbitration has become international, and this, worldwide, it is accepted as a mode of dispute resolution because of its neutral nature, that you can provide a neutral venue. Like, for instance, the French party and the Indian party can have a seat of arbitration in Singapore or in UK. So we can do the arbitration there. The third reason why the international arbitration gained popularity, because of its very important feature, flexibility. Now, what is flexibility? The procedural flexibility is what I'm talking about. If you go to the court of any country, you see there are a lot of technicalities. Code of civil procedure is applicable. Every country has its own evidentiary rules, etc. Now, to get rid of them, the beauty about arbitration is that it is less technical, very flexible, and therefore you do not have to worry about any kind of complications regarding technical procedure and rigid procedures that have to be complied with. So you just have to make it very smooth and convenient without any hassles, and there are no technical objections that will resist arbitration or to delay it further. So I think that's another reason why countries prefer going for arbitration in such disputes. Now, another feature is that if you do not go for arbitration, you don't get a choice to choose the judges. And imagine there is a dispute which is very, very complicated. Perhaps a dispute involving millions of dollars and which has very high technical issues involved regarding engineering, procurement, or anything, drawings, delay. Now, for an ordinary judge who's probably from one jurisdiction, it may not be possible to have that kind of knowledge of the international laws, because the judge has been sitting in a country and doing matters of that country as per the law of that state. But in arbitration, the advantage is you can get any arbitrators globally. Like in some of our arbitrations, we have seen arbitrators coming from UK, Canada, France. So, these arbitrators who are known worldwide and have a very, very good reputation, and they are experts in the subject. So for a construction dispute, you can get a construction expert. If the dispute involves maritime arbitration, then probably you can get a maritime expert. So somebody who understands the subject pretty well and who can do justice to the subject, to the issues, to the adjudicate effectively and get into the reasoning part of it. In short, to have an expert on the panel. That is the reason why arbitration is gaining popularity internationally, and that's why international arbitration has flourished in these years. Last but not the least, and the most important one, is party autonomy, of course. So generally, if you do a matter in a court, you do not have any control. You can't choose a judge. You can't choose the rules. You have to, stick to the schedule framed by the courts and the civil procedure. But in an arbitration, party has a freedom, because party autonomy means freedom of parties, wherein parties get to decide how they want their disputes to be adjudicated. They can choose a neutral forum. They can choose any law that they want for resolution of their disputes. And they can choose the flexibilities, what will be the manner of resolving disputes, what procedures will be applicable. So, this kind of freedom you don't get anywhere else. And because you are getting it through arbitration, I think that's the reason why arbitration has gained popularity all over these years. Now, another example that I'd like to give you of BITs, I was on BIT. So the bottom line is that bilateral investment treaties have been one of the major reasons why arbitration and investment in the countries have increased. Now, the problem is with the recent India BIT model, there's something not right with us. I'm emphasizing on the Indian perspective and giving India as an example again and again, because I think that would be better for us to understand. So we have seen that India has terminated more than 64 or 65 BITs, and India has lost one BIT after the other. India lost the White Industries case. India lost Vodafone. Now India lost Keynes also, $1.2 billion. Now, what is the reason? Why are we losing? That is the issue. And when we lose, we are constantly challenging it. Now, again, you need to understand that if the government of a particular country or if the legislature is challenging every award as a thumb rule, then this gives an impression that, look, if you want to do business with this state is going to fight till the end, and your money will be stuck forever, and it is not going to enforce awards. Even if you win, you will not be able to get money easily. So therefore, it's better not to invest money in this country. And anything unreasonable that comes up, like I'll give you an example. In COVID, the insolvency and bankruptcy was suspended for some time. And law changed so that people do not become insolvent last year. Now, when an investor invested in India via BIT, the investor was under an impression that tomorrow, if my money gets stuck, I will be able to take it out by using this law, insolvency and bankruptcy. This is just an illustration that I'm giving you. Now, billions of dollars invested, disputes are going to happen. And suddenly, the investor gets a shock that the law has changed. The time at which I had invested, the law was X. And now the law is why. So I cannot recover my money via insolvency and bankruptcy, which was one of the reasons why I invested in this country at the very first place. So this is another issue. And then they challenged the fair and equitable treatment. And they said this is not something which is acceptable to us. Because at the time we invested, this was the law, and you changed the law. And then BIT, of course, there's a clear violation of the fair and equal treatment clause in a BIT. So these are the kind of challenges. And when we do such things, or any state will do such things, they will give an impression that, look, we are really not keen on enforcing arbitral awards. We will fight till the end. And this way, no investor would want to invest in a country. The other issue that we have seen is the seat of arbitration. Now, what do you mean by the seat of arbitration? The seat of arbitration is the epicenter of an arbitration. So if you and I decide a dispute, that if disputes will happen tomorrow, we will be going to Singapore as a seat of arbitration or Hong Kong as a seat of arbitration, then the courts of the seat alone shall have jurisdiction over everything, like appointment of arbitrator, challenge to the arbitrator, challenge to the award. All of these proceedings can only be filed in the seat court. And therefore, seat plays a very, very important role. We have seen that many investors prefer Singapore as a seat or London as a seat. Now, what is the reason why people are not choosing India as the seat of arbitration? New Delhi or Bombay. The reason is that they have seen. So whenever any seat is going to be determined, any state, they first do their research. They see what is the approach of the courts of that seat. How much time do they take in enforcing awards? How much time do they take in setting aside an award? And whether they are arbitration friendly or not. The idea is to show minimal judicial intervention. The Indian courts have passed very good judgments like Sangyong and many recent judgments, if you see BGS, Soma, etc., wherein they have tried to make an attempt. Now, they've made an attempt to give a message that, look, we are promoting arbitration and we are expanding arbitration, trying to ensure that it is enforced in all aspects. But the problem is that one bad judgment comes, it takes us 10 steps back. So you move 2 steps forward and 10 steps backward. And then a bad judgment takes 10 years to do the wrong which it had committed, to do away with the wrong which it had committed. So any state that aspire to be a seat of arbitration and get that kind of exposure and to show itself as a hub of arbitration must respect the law which was there in place at the time when investments were made, must provide a comfortable environment to the investor community, should not interfere in business, ease of doing business should be provided. The court should not interfere with foreign awards. Foreign awards must be enforced and pro-enforcement bias must be adopted. That no matter what, we are going to enforce the awards. So if you pass such laws, like for instance, a very good move in 2015, what India did, we removed patent illegality as a ground to set aside the foreign awards. So now if an foreign award is challenged in any court on the ground of patent illegality, then you cannot challenge it because patent illegality is not a ground available in case of a foreign award. Only in case of domestic award, you have that ground available. Now, all in all, what I have seen is that internationally, nowadays, things are changing. We are moving towards multi-tier arbitration clauses. Singapore, for instance, is also promoting mediation. We have seen med-arb clauses and arb-med-arb. So, which means that mediation and arbitration. So when there is a dispute resolution clause in any agreement, the endeavor first is to amicably resolve the dispute with the other party. And that's why that's the med part of it, mediation, med-arb. And then if mediation fails, then they refer the matter to arbitration. So I think these are the kind of, now the idea is to expedite the dispute resolution, to resolve the disputes amicably if possible. More emphasis is being paid on such kind of initiatives so that investors feel that, yes, this country and this jurisdiction is actually trying its best to resolve disputes expeditiously and conveniently. Public policy, like I said, has been a major bone of contention. The countries which have interpreted public policy widely have been criticized globally by the experts. And good jurisdictions are considered to be those jurisdictions which are construing public policy very narrowly. For instance, if you challenge an award in US or UK or France or Sweden, and you take a ground of public policy that this award cannot be enforced because this is against the public policy, then their Supreme Courts and their respective courts have said, no, public policy is not going to be expanded to this extent. So unless something which is so grossly against the public policy, that it's apparent, they will not interfere with foreign awards and they will enforce it quickly. So that has been the reason why these jurisdictions became the hub of arbitration and they gained popularity. Another important aspect to be kept in mind, apart from public policy, is the flexibility that the jurisdiction provides. And we have seen recent growth of BITs. And now India has signed a India-UAE BIT, wherein trade is going to come via UAE. Dubai, for instance, has done very well for itself in the past few years, and it has become a hub of arbitration. There are DIFC courts where there are a lot of law firms from worldwide. There are a lot of lawyers across the globe, and financial disputes and disputes pertaining to commercial matters are being handled by foreign lawyers in English. And now Dubai is also promoting the companies to come and without having any kind of partnership with any local, you can have 100% controlled company. So I mean, these are the kind of lucrative offers that the jurisdiction has to give to get that kind of create an environment for the world at large to come and do business there, so that it becomes a hub of arbitration. And if you look at the other example like Malaysia and Singapore, even they are doing pretty well for themselves to show or reflect themselves as a hub of arbitration. So I think I'm going to exceed my time. So I'll just quickly finish so that if you have any questions, we can have that discussion. So all in all, the gist of what I have said is that arbitration has evolved over the years, and due to its features like flexibility, party autonomy, cost effective, and procedural flexibility especially, and enforceability and international nature, it has gained a lot of popularity in the past few years. And that is one of the reasons why it has grown. And the jurisdictions which have interpreted public policy narrowly, who have enforced the arbitration agreements, who have enforced the enforcement of the awards, they are the ones which are preferred. And at the end of the day, investment is directly associated or connected to your approach towards arbitration worldwide. So thank you, everyone. And I think I was able to explain or make some sense out of it. And it was really a pleasure telling you about this discussion. I kept it slightly candid. So any questions that you may have, you may please ask me.
Now we are moving towards the end of the session. So if anyone is having any kind of question for our speaker, please ask them in the chat feature and our speaker will respond to your question one by one. Sir, by your kind permission, if you permit me, it would be a privilege for me to read out the questions for you.
Yeah, please go ahead. Read the question and I'll answer.
Sir, the first question is, the seat of arbitration would also have the authority over enforcement of the award in the concerned country. It's a question.
Okay, so enforcement, it's slightly different. Enforcement is linked to the assets. So if the asset of a particular party are located in some state or some country, then you have to go in that state, because only the courts of that state will have power over the property which are located. Like for instance, my property is in Bangalore. So you have to go to the courts in Bangalore to enforce it, because you need attachment of the assets. So that's how it works.
I hope first question has been answered. So second question is, DIFC courts follow their DIFC laws or any others?
Basically, it completely depends. For instance, they have their own rules. Like DIAC, it's a center. In DIAC in Delhi, if you look at, they have their own set of rules. And once you go to these centers, you are bound by the rules of that center. But one thing to be kept in mind, it depends on the arbitration clause. If the law which is applicable to the arbitration is a foreign law, then that particular law will prevail. For instance, if parties have chosen English law, then parties will be governed by the English law.
Sir, our next question is, how difficult and time consuming would it be to enforce an award in case it is passed against the government, especially in case of award if it is to be enforced in India?
Well, that's a very interesting question. Who has asked this question? Must be
Mr. Mayank Bangal. Please,
mine.
your mic, sir.
Yeah, that's a very good question, man. So basically, against the government, I would say it's easy also, and it is not so easy because what we have seen is that the approach of the government is to challenge each and every award that comes. Whether it is a reasoned award or it's not a reasoned award, they will challenge and they will fight till the end. First, they will challenge under 34, then they will challenge in 37, then they will go to the Supreme Court in the SLP, and then they will contest it till the end. So it is slightly, but the good part is that the assets are there. So you don't have, your money is not going anywhere. But with private parties, the issue is that even if you get the execution, private party may go insolvent, bankrupt, and you may not be able to execute, or it may run away, leave its business in India and run away to some other country. So yeah, that's how the thing is. Yeah, that's a good question.
So our next question is, recently SIAC started hearing the disputes between Amazon and FCL, and very firstly they challenged the jurisdiction of the tribunals. It's a kind of trend in such commercial matter. What are your thoughts on same?
I must say that your audience is pretty interesting and they know quite a lot about the matters which are going on. Impressive. Okay, so the future retail dispute that happened because Amazon and Reliance are fighting over future retail group. And yes, the emergency arbitrator was appointed. Yes, he passed an order and that was challenged. But the problem is that we need to recognize and enforce these emergency awards and the orders passed by the courts. And that's what Justice Midha did in Delhi High Court when the matter came up. And if you read the judgment, he has given excellent reasoning. He said this order will be treated as an order under Section 17 for all practical purposes. And he recognized the orders passed by the emergency arbitrators and enforce it. So I think that's the approach we need. If we keep challenging, we are just giving a very, like what I discussed, we are giving a very bad signal to the investor community. And we are actually showing ourselves as a jurisdiction or probably parties which are just ready to fight and not ready to accept the international arbitration practices. So yeah, it's important to enforce such orders.
Okay, sir. So our last question for today would be, would pre-deposit for a challenge apply even in case of an award against government because there exists power of aids?
So is that Mayank again asking about the government? Okay.
Yes.
So the thing is that there have been a recent amendment in 2021 wherein they've said that we will not be, there is a ground which is available that if there is corruption and fraud allegations involved, then in that case, you can seek a stay on the award without any deposit or any conditions. So it's an unconditional stay. So governments are definitely going to use it because earlier there was no such thing. And I think it's applicable for private and there's no specific mention of government. But yes, I think this kind of amendment has been brought in to protect the interest of the government, PSUs also, because PSUs were the ones losing mostly. And they were asked to deposit like 50% of awards, where awards were going on 1,000 crores. So for depositing 500 crores at once was something which is problematic. And therefore, this amendment has been brought in that there would be an unconditional stay on the operation of the award if fraud and corruption allegations are involved. So as long as any party is taking these allegations, they can get an unconditional stay. But nothing specific mentioned about the government. There's no privilege of the government or PSU.
Sir, our audience are so much enthusiastic and they are having a lot of questions, but we are having the shortage of time and it would be the last question for right now. So the
Okay.
last question is, uniformity has been a consistent issue for international arbitration. Do you think uniformity's approach of arbitral tribal, at least the institutional one, will improve the concerns?
You're right. See, uniformity will always be a problem because not every country can be on the same page. Indian courts and Indian centers, institutions will be having a slightly different approach than countries which are Singapore, Dubai, US, UK. Every country will have a very different way of looking at things. So uniformity, I don't know how it will happen, but yes, we can have uniformity in the centers. Like CIAC has uniformity. So if you are approaching Singapore International Arbitration Center, you will see uniformity in their approach, in their operation, implementation, procedural aspects, and consistency of the Supreme Court should be there. It will be there. And that's what we have seen. But I think the best thing is that uniform practice should ideally be pro-enforcement approach, that all the countries must say that, yes, we will give arbitration all that it needs to flourish, and we will not interfere with arbitration agreements as well as arbitration awards. And we will keep the scope of interference extremely narrow. That's the uniform approach which is supposed to be required. Slightly here and there in practice and implementation, it may differ, but the objective, the underlying objective should be the same. So that's my take on it. And for people who have not been able to ask their questions, I mean, I'll be happy to get your questions. You can ask me on LinkedIn or anywhere that you want. I'm really sorry, due to paucity of time, it will not be possible to answer all the questions here. But it was really lovely hearing these questions and excitement and enthusiasm from students. Such a good audience after a long time on a Sunday morning.
Thank you so much, sir. It was all your aura, which make all of us so much enthusiastic. Now we have come to the end of this lively session. It has been my pleasure to moderate all the participants of this session. I express my heartfelt gratitude on behalf of organizing committee, entire law department of JCR's University, amicus curiae, and all the faculties of law to take the opportunity to thank our distinguished speaker, Advocate Tariq Khan, for giving his valuable insight. It was a very insightful session, and we are indeed grateful for such sessions, sir. Now, I would request Dr. Namita Jain, Head of Department, JCR's University, to give vote of thanks and felicitate our guest speaker with e-memento as a token and gratitude and an honor. Over to you, ma'am.
Thank you, Srishti. Thank you so much, Tariq Khan sir, for accepting our invitation.
My pleasure,
And
ma'am.
for such an informative and interactive session. Please accept this e-memento as a token of gratitude from amicus curiae and faculty of law, GCR's University.
Thank you so much,
sir.
Thank you, ma'am. It's my pleasure.
Excuse me. Good afternoon, sir. Is that memento visible or not? I think
Yeah, it was visible.
Oh, okay, okay, fine. Okay. Thank you.
Thank you so much, everybody. Now I would like to give this to Rupanshi. Over to you, Rupanshi.
Rupanshi?
Anyone give right of unmuting to Rupanshi?
Yeah, I'm so sorry. I was not able to unmute that time. So, just a minute. Herbert Read once said, at all events, arbitration is more rational, just, and humane than the resort to the sword. With this enlightening thought, I, Rupanshi Agarwal, moderator of this session, would like to extend a very warm welcome to all of you to the second part of the third session of the National Virtual Bootcamp on Performance and Practice of Arbitration. Now, with extreme honor, I would like to introduce you all to the speaker of this session, Ms. Shalaka Patil. We're highly honored to have you as our guest speaker for this session, ma'am. She is a partner in the dispute resolution practice at the Mumbai office of Cyril Amarchand Mangaldas. She has worked in matters involving shareholders dispute, cross-border investments, investor-promoter disputes, disputes in the healthcare, infrastructure, oil, gas, and energy sectors. Through her career, she has acted in several arbitrations, both institutional, as in SIAC, ICC, LCIA, DAC, IMC, etc. and ad hoc seated in Mumbai, Delhi, Ahmedabad, Singapore, Zurich, and London. She was recently ranked as a key lawyer in CAMS dispute practice by Legal 500. Also brings international experience, having previously worked at law firms in Mumbai, Delhi, and a leading law firm in Singapore in 2014 in their international arbitration practice. She has worked as a foreign associate for a short term at a leading Jewish law firm in their international arbitration group. She has also interned in the international arbitration practice of top law firm in London. Just a bit of a notice I would like to bring up to you. If you have any questions during the session, please type them into the chat box. Your questions will be answered at the end of the session. So, without taking much time, I would like to invite Shalaka Patil ma'am to kindly address the audience. Over to you, ma'am.
Thanks very much, Rupanshi. Good afternoon, everyone. Thank you, JCRC University, and particularly the Faculty of Law. Thank you to the Dean and all the professors. And of course, a big thank you to all of you attending this session today on a Sunday afternoon. You guys are clearly the arbitration nerds that they talk about, that you've taken Sunday afternoon to come and listen to a session like this, which, as Tariq also was saying, is quite encouraging. So today I'm going to talk about something that is often spoken about in arbitration. You all will have read about it, seen articles, perhaps written articles about it, which is your question of seat and venue in arbitration and laws of an arbitration, or what are the various laws that one has to look at when an arbitration is conducted. These questions are often seen in practice. They arise repeatedly, either as a respondent or as the claimant. You will raise these issues, particularly at the threshold, and these are issues that make or break your arbitration. So they're important. So with that background, if someone could kindly share my PPT, I'll begin right away.
Good afternoon, ma'am. I'll be sharing the PPT. Please instruct me to change the slides. Ma'am, just a minute. I'm sharing.
I'll do that. I'll let you know when the deck has to be changed. Thank you.
Sure, ma'am. Just a minute. I am having some issue. Sir, can you please share the PPT? Actually, there is no Acrobat Reader share in my share screen. I think there is some issue.
Okay, I'll do that.
Okay, I am so sorry.
Is it in the form of PDF? Because I'll just share it.
Yeah, it's in PDF form.
Yes, yes. Okay. So is it visible now?
Yes, I can see it. Can everyone else see the screen? Is the screen visible to everyone?
Yes, ma'am.
Okay,
Yes.
great, great. Okay, so next slide, please, if we could go to the first slide. Yeah, Thank you. So let's begin with the very, very basics of the issue of seat. What is a seat of arbitration? Why is it even called a seat of arbitration? A seat of arbitration is the situs or the legal jurisdiction where the arbitration is said to be located or seated. This concept is significant not just because it may well be the place where the arbitration is conducted, but it's also relevant from the point of view of often determining the lex arbitrae, which is your law governing the arbitration agreement, and the curial law, which is the law that the courts that exercise supervisory jurisdiction over the arbitration proceedings will apply. Therefore, why are these laws relevant even? These laws are relevant because seat is very often determinative of what law you will apply when you interpret an arbitration agreement, meaning what will be the law of the arbitration agreement. And similarly, this is relevant because the courts that you will approach for issues such as interim relief, for issues such as challenging an award that it may not be in your favor, or for any challenges to the, say, the jurisdiction of the arbitrator upon such challenge having succeeded or failed before the arbitrator itself, all of these issues will be determined by the courts of seat. Next slide, please. Now, often synonymous with the word seat, but unfortunately without realizing that there is a world of difference between those two issues. Arbitration clauses also describe the place where the arbitration is being held as a venue. But a venue is very, very different to that of a seat, because a venue of arbitration may not have, and I'm using the word may not with some care, because as you will notice when I discuss some judgments going forward, venue has also held to be a seat of arbitration. But ordinarily, a venue is merely the place where you conduct your arbitration proceedings. It is a place of convenience that the parties decide in their arbitration agreement, or failing which your arbitral tribunal may decide the venue. Venue is where your seat of arbitration could be, say, New Delhi, but all parties could be located, say, in Bombay, and you could perhaps conduct your arbitration, therefore, in Mumbai. So a venue is just the geographical location and does not usually affect the choice of your seat. Next slide, please. So what is really the cause of confusion between these concepts of seat and venue? If on a plain reading, they're fairly clear and simple. Usually the problem arises because of pathological arbitration clauses, which could, one, not talk about either a seat or venue, or use ambiguous terms like arbitration to be held in Hong Kong, location of arbitration to be Singapore, or just say nothing about venue and seat and instead say that SIAC rules will apply or ICC rules will apply. So it's clauses of this nature and it is language of this nature which has led to interpretation of these terms in a large number of cases in jurisprudence, both in India and outside of it. And therefore, what has happened is over a period of time, courts started to develop a regime for interpreting these issues that arise in arbitration. And one important test that has been derived is called the closest connection test. And I will be discussing this as well. The closest connection test is not just relevant for the determination of seat or venue of arbitration, but it is also relevant sometimes to determine what is the law of the arbitration agreement and indeed what is the proper law of the contract. Next slide, please. So coming to sorry, 1 minute. Okay, thank you. Coming to our law itself, how does the Indian Arbitration and Conciliation Act define seat or venue, or how does it talk about these concepts? Well, neither the word seat nor the word venue has been defined in our act. In fact, our act chooses to steer clear of both those terms. Our act instead uses the word place. Section 2.2 of the act says that this part, meaning part 1 of the Arbitration Act, shall apply where the place of arbitration is in India. Here, where the word place has been used, it means seat of arbitration. Section 20, on the other hand, uses the word place to mean both seat and venue. Section 21 says that the parties are free to agree on the place of arbitration, meaning parties can choose any seat that they want to. Section 22 says that failing any such agreement, the arbitral tribunal has to determine what this place of arbitration or seat of arbitration will be, depending on the convenience of the parties. And then subsection 3 says, notwithstanding subsection 1 and 2, arbitral tribunal may, unless otherwise agreed by the parties, meet at any place that it considers appropriate, depending on, where witnesses are to be heard, experts are to be heard, inspection of the documents is to be conducted, etc. Now, 23, when it refers to the word place, and especially since it begins with the word notwithstanding 1 and 2, has been interpreted to mean that it is speaking of venue. But giving context to this provision has become possible only on a closer reading of the provision, and of course also as a result of the Balco judgment of the Supreme Court. I'll give you one interesting example in the context of section 23 that happened in a case that we had handled called Stemco, right before the Bombay High Court. The question that arose before the court was that the venue of arbitration that the parties had agreed upon was Mumbai. However, one of the witnesses was in Singapore and for certain legal reasons could not come to Mumbai for the purposes of cross-examination. Therefore, the court had appointed a commissioner. So Stemco had requested that the commissioner and other parties are flown out to Singapore where this witness is commissioned, and the witness should be cross-examined in Singapore. The opposite party objected and said that nothing doing, that cannot be changed, that cannot be done, because that would amount to changing the venue of arbitration from Mumbai to Singapore, and that's not permissible. The court did not agree with this logic. The court said that Singapore is a mere extension of Mumbai. Because of these various reasons and the witness not being able to travel to Mumbai, it has become imperative for the conduct of the cross-examination through the commissioner in Singapore. Therefore, such a deviation of process cannot be considered as a change in venue because a video conferencing facility is being employed and the arbitrator and others are sitting in Mumbai. It is only that the witness and the commissioner and some parties will be in Singapore. And for that reason, it is still to be treated as Mumbai being the venue. So this is the interesting way in which courts have to go around these clauses and interpret them so that, you marry these somewhat ambiguous and varying principles. Next slide, please. So the question is, why do we use the word place of arbitration in our law? The reason being that we follow the ancestral model law, and model law also uses the word place instead of seat or venue. And this is the reason why our law has adopted the same language. In fact, the 246th Law Commission report had recommended, as you all saw previously, that in 21, 2, and 3, the words seat and venue should be used. But ultimately, the legislature in its wisdom decided not to do that. Next slide, please. How do our arbitral institutions refer to seat or venue in their rules? How do they deal with this intractable problem, as some may call it? Well, they typically tend to either specify the words seat or venue in their rules, or then they make it so clear in the language that what they're referring to is in fact the seat or the venue, even if they may not use those words. So for example, MCI in 23.1, Rule 23.1 uses the word seat in place of, instead of place. In 23.2, the MCI rules say tribunal may hold hearings, meetings, and deliberations by any means it considers expedient or appropriate, and at any location it considers convenient or appropriate. Now, naturally, this suggests that the word location here is synonymous with venue. The SIAC rules in Rule 21 say that use the word seat again in place of venue. LCI rules 16.2 provide that London is the default seat in the absence of any agreement to the contrary between the parties, or if unless the tribunal finds another seat appropriate. A number of other institutions also adopt a similar rule as LCI. Next slide, please. One other clarification that LCI rules provides is that regardless of the geographical location, which is your venue again, chosen by the parties for deliberations, consultations, etc., the seat is where the award is said to have been made. The ICC rules don't use the word seat and venue. Instead, they say in 18.1 that the place of arbitration shall be fixed by the court unless agreed by parties. And in 18.2 and 3, they say they refer to location in place of venue. But much like in section 20, if one is to interpret this provision, it becomes sort of clear as to what the rules are talking about. Moving to the next slide. Now, I'm going to start to briefly discuss some very, very important Indian cases in the context of seat and venue. I think if you familiarize yourself with these cases, the foundational principles of how concepts of seat and venue have been interpreted in the last, let's say 10, 15 years by the Supreme Court will become very clear. So I would urge all of you to, go back and reread many of these cases because it really helps in solidifying these principles. So if one is to sort of go back right in the beginning to what is it that Indian jurisprudence relied upon heavily when making a determination of what is a seat and what is a venue? And the answer would be found in the case of Roger Shashua versus Mukesh Sharma. This is an English law case, but it has been adopted in Indian law and is treated as good law in India. The Shashua case gave rise to the Shashua principle. And what is this Shashua principle? That is described succinctly in a paragraph I have quoted here on my slide, and I'll read out as well. Just by way of background, in this case, London was the venue of arbitration, but there was no clarification in the clause on what is the seat. But the arbitration was governed by ICC rules, which means that it was to be conducted according to ICC rules. So the question before the court was that what would be the seat of arbitration? Court found that wherever there is an express designation of a venue and no designation of any alternative place as the seat, combined with a supranational body of rules governing the arbitration, which means your ICC rules, and no other significant contrary indicia, the inexorable conclusion is that the stated venue is actually the juridical seat of the arbitration proceedings. This means the court said two things. One, the court said that there is a venue and no seat designated. Plus, there is something more. What is this something more? The something more here is the supranational body of rules designated, which in this case was ICC. And second important thing it said is that there is no other significant contrary indicia, meaning that nothing else in your dispute resolution clause indicates that the venue is not in fact the seat. If these two conditions are fulfilled, then that means that your venue of arbitration also will be your seat of arbitration. This principle has been followed in a number of judgments, usually followed in international commercial arbitration cases, but the Supreme Court has also followed this principle in a domestic arbitration case, holding that Bhubaneswar is the seat and not the venue, in the case of Brahmani Pellets versus Kamchi Industries. And the Supreme Court in another eponymous case itself, Roger Shashua versus Mukesh Sharma of 2017, recognized that the Shashua principle is a part of Indian law. Next slide, please. Next, we come to the seminal case of BALCO. Of course, no arbitration conference and no arbitration webinar is ever complete unless BALCO is mentioned. The holy grail of arbitration in India is BALCO. But we don't often look at the arbitration clause in BALCO itself. If you do look at the arbitration clause, it said courts of arbitration shall be held, the court of arbitration shall be held wholly in London. It's a very oddly worded clause because it's not quite a court of arbitration, but the court was tasked with interpreting a clause of this nature and of identifying as to whether part 1 would apply in such a case, and we all know what the court said eventually. Here in this case as well in Balco, the governing law was Indian law, and what the court said is that when you're faced with the issues of a seat or venue, you determine them depending on the words used in the provision and depending on a case-by-case basis. Next slide, please. The next paragraphs that we've quoted here from Balco are actually key to how the court instructs us to identify these provisions or to interpret these issues. I'm going to just read this out. The legal position that emerges from a conspectus of all the decisions seem to be that the choice of another country as the seat of arbitration inevitably imports an acceptance that the laws of that country relating to the conduct and supervision of arbitration will apply to the proceedings. It would therefore follow that if the arbitration agreement is found or held to provide for a seat or place of arbitration outside India, which means the court naturally interpreted London there as the seat, then the provisions that the Arbitration Act would govern the arbitration proceedings would not make Part 1 of the Act applicable or enable Indian courts to exercise supervisory jurisdiction over such arbitrations. The rest of it, of course, you know as to what the judgment said. Next slide, please. One other very important case on the issue of seat is the case of Enercon. Enercon brought into the fray the closest connection test. In Enercon, the question before the court was that whether the designation of venue as London by the parties in the clause implied that the seat was London as well. Here, the Supreme Court took a slightly different approach. The court applied the closest connection test, and it found that apart from applying London as merely the venue, applying meaning that the clause identifying London as merely the venue of arbitration, there was no other connection between London and the dispute at hand. Parties had specifically opted for Indian law as substantive law, law governing the arbitration agreement, and the witnesses were there, the proceedings in that manner, the contract, everything was tied to India. And for these reasons, the Supreme Court found that it was very, very much so that India itself was the seat of arbitration. Next slide, please. Now, the next case is Union of India versus Hardy Exploration. This one is very controversial because several arguments have been made about how this case does not follow the Shashua principle. Here, the arbitration clause said that the venue of conciliation and arbitration pursuant to this provision, unless parties otherwise agree, will be Kuala Lumpur. And the question before the court was whether Delhi or Kuala Lumpur is the seat of arbitration. Next slide, please. The court found that Delhi would in fact be where your Section 34 challenge proceedings would be maintainable. Delhi would be the correct court and not Kuala Lumpur, because the court felt that the arbitrator had not determined any seat of arbitration. Kuala Lumpur was merely the place where the arbitration was conducted, and the contrary indicia, which your Shashua principle talks about, of in fact the parties being connected with India in some manner, etc., indicated that Delhi would in fact be the correct court and not courts of Kuala Lumpur. So the court says that, be it noted that the word determination requires a positive act, and in the case at hand, the only aspect that has been highlighted by Mr. C.U. Singh is that the arbitrator held the meeting at Kuala Lumpur and signed the award. That, in our considered opinion, does not amount to determination, meaning that the arbitrator does not decide this issue. The clause is categorical. The sittings at various places are relatable to venue. It cannot be equated to seat of arbitration, which has a different connotation, as has been seen in Reliance, Harmony Shipping, and Roger Shashua. Next slide, please. So the court also talks about this principle that I was saying, which is place becomes seat when one of the conditions is satisfied, which means something else, and also the condition of no contrary indicia. So the court says something else is added to it is as a concomitant. In Shashua, it was the ICC rules. Here, the court found there is nothing such being there. But a later case of the Supreme Court in BGS Soma held hardy exploration to be per incurium because it said that it had failed to follow Balco. Next slide, please. Now, in the BGS Soma case, an interesting question came before the Supreme Court. It had to interpret the question of whether or not the seat was Delhi or Faridabad, because the clause said arbitration proceedings shall be held at New Delhi / Faridabad. And arbitration was held at Delhi and an award was signed there, but the Section 34 provisions of Section 34 petition was filed by the respondent before the Faridabad courts. The Supreme Court confirmed the principles in Indus Mobile, Justice Nariman's own judgment. BGS Soma is also his judgment, where the Supreme Court had held that seat courts have exclusive jurisdiction. So even in BGS Soma, the Supreme Court affirmed this principle, and therefore it found that it is New Delhi where a Section 34 would be available and not Faridabad. And this is the case where, as I said, they held hardy to be per incurium. Next slide, please. Then came your case of Mankatsu versus Air Visual. Mankatsu is the case which sort of consolidates BGS Soma, hardy exploration, Shashua, all of these together, considers a number of cases. Doesn't it identifies that both are of a coexisting, co-equivalent bench, and says that one has found the other to be per incurium. In Mankatsu, it was interesting. Mankatsu, the clause says, this MOU is governed by laws of India without regard to conflict of law principles, and courts at New Delhi shall have jurisdiction. And in terms of the arbitration, it says that the disputes shall be referred to and finally resolved by arbitration administered in Hong Kong. The place of arbitration shall be Hong Kong. And next slide, please. On the basis of this, the court found that Hong Kong would be the seat of arbitration and not Delhi, because Hong Kong was where the arbitration was also administered. It was the place of arbitration, and only insofar as Section 9 or other proceedings for interim that the court would that the parties would come to India, that courts of Delhi would have jurisdiction. So the court says it is well settled that seat of arbitration and venue of arbitration cannot be used interchangeably. It has also been established that mere expression of place cannot be the basis of determining the intention of the parties, that they have intended that place as seat. The intention of the parties as to seat should be determined from other clauses in the agreement and conduct of the parties. So on this basis, Hong Kong was held to be a seat. Next slide, please. Last case on this issue is the case of Inox versus Jayesh Electricals. This is a little bit controversial, and I'll leave it to you all to tell me, or we can or think about this, or on whether you agree with the outcome. In this case, Jaipur was the venue and courts of Rajasthan had jurisdiction. This was identified in the arbitration clause also. But parties later agreed to have proceedings in Ahmedabad. The question before the court was that whether a 34 challenge would be maintainable in Jaipur or in Ahmedabad. What the court found was that because the parties had changed the venue from Jaipur to Ahmedabad, in a sense, Jaipur itself was also the seat which was changed to Ahmedabad, and therefore this 34 would be maintainable in Ahmedabad. But I could argue to the contrary and say that, in fact, if it says courts of Rajasthan have jurisdiction, there is a suggestion that, in fact, Jaipur continued to be the seat and Ahmedabad was merely the venue. So these are interesting cases, and I think they are open to interpretation. And I'm quite certain that going forward, maybe a different kind of interpretation is placed on a new case. Now I'll very quickly, because I recognize that we're very close to nearing the end of time, I'm going to quickly deal with the second aspect of my presentation. If you could go to the next slide, please. On laws of arbitration, what are the laws usually that one looks at in an arbitration? Because this is another very confusing area where one often gets questions, and even if you've practiced in this field for a number of years, these questions are sometimes quite tricky because the jurisprudence has evolved in different directions. So the main three buckets in which I could place laws in an arbitration are: one would be substantive or applicable law, which is your main proper law of the contract that governs the contract's performance itself, that governs the interpretation of your main contract. The second would be your law of your seat. The law of your seat often determines the curial law of the courts and also determines the lex arbitrae, which is your law of the arbitration. And the third would be the law governing your arbitration agreement. Many cases which began in particularly in India with NTPC say that the law governing the arbitration agreement, in the absence of a contrary indication, follows the law of the main contract. Whereas there are other cases which say, which is the contrary indication in question, that laws of the arbitration agreement typically follow the laws of the seat. Next slide, please. So NTPC is the seminal case which discussed this in some detail in India. There are two principles NTPC expounded that are important to remember. In NTPC, the seat was London and the ICC rules governed. Governing law was Indian. So the court found that two things. One, where there is no express choice of law governing the contract as a whole, nor is there any express choice of law governing the arbitration agreement. In such a case, the court held that the presumption in the absence of any contrary indication is that the parties intend that the proper law of the contract as well as the law governing the arbitration agreement are the same as the law of the country in which the arbitration is held. That is the seat. However, where there is an express choice of the proper law of the contract, which means you have a governing law, then in such a case, the arbitration agreement is governed by such proper law. Since the arbitration agreement, though collateral or ancillary, is considered as a part of the main contract. Next slide, please. On the basis of this, the court found that parties had chosen proper law as Indian and therefore accepted exclusive jurisdiction of courts of Delhi, and therefore it found that that is the same law that would govern the arbitration agreement. So the court says neither the rules of procedure or for the conduct of the arbitration contractually chosen by the parties, which is ICC rules, nor the mandatory requirements of the procedure followed in the courts of the country in which the arbitration is held can in any manner supersede the overriding jurisdiction and control of Indian law and Indian courts. Next slide, please. Sumitomo versus ONGC is on the same lines, where it says that the law governing the underlying contract was Indian law. Parties had not specified the law governing the arbitration agreement. Seat was London and ICC rules were provided for. Supreme Court says that law of the arbitration agreement would be Indian law. This case is a little bit controversial because some argue that its conclusions are curious, because it said that Foreign Awards Act did not apply to the arbitral award if the arbitration agreement was governed by Indian law. And the court also found that the law of the arbitration agreement would govern set-aside proceedings as opposed to the curial law, because according to the court, the curial law stopped operating once the award was rendered, rendering even the naturally the tribunal functions official. So this is a little bit of a oddball, but it's important because it recognizes some of these principles of NTPC. Next, we come to the case of Sakuma Exports versus Louis Dreyfus. There, the appellant was Indian and the respondent was Swiss. When disputes arose, they submitted the disputes to arbitration. Clause, as you can see on your screen, says disputes to be submitted to the Refined Sugar Association in London and for settlement according to their rules of arbitration. Contract governed by English law. So relying on NTPC, it says arbitration agreement, even though ancillary is part of main contract. And the Bombay High Court that way held that proper law expressly chosen by the parties, which is English law, would be the law of the arbitration agreement as well. Next, we come to the case of, on the next slide, please, Yograj Infrastructure versus Sanyong. Here, the governing law was Indian law, seat was Singapore and SIAC rules. Very, very interesting. So the court first recognizes the NTPC principle, which is that ordinarily your law of the arbitration agreement follows your proper law. But then the court looks at the contrary indicia principle and says, however, here parties have chosen SIAC rules. SIAC rules at that point in time had a rule 32, which says that if the parties had not chosen the law of the arbitration agreement, it would be Singaporean law. And on this basis, they found that the law of the arbitration agreement was Singapore law. Next slide, please. Last two cases that I'll talk about, you will find them quoted in a number of these cases earlier discussed, where talking about seat, venue, and laws in the arbitration. One being the case of course, Sula America. and second being Naveria Amazonica. Sula America recognizes your closest connection test principle, which we were talking about. If we could go to the next slide, please. So Sula America held that curial law follows seat, and as does the law of the arbitration agreement, which is your contrary indicia principle that we spoke about in Yograj. Naveria Amazonica, on the other hand, also recognized this principle, but specified that where the parties have failed to choose the law governing the arbitration proceedings, those proceedings must be considered, at any rate prima facie, as being governed by the law of the country in which the arbitration is held, on the ground that it is the country that is most closely connected with the proceedings. So as you can see, closest connection test has been followed and applied in a number of these cases, in a number of these permutations, combinations, and is quite interesting. So with that, I conclude my talk with you all today. I hope that it was of some interest to you all, and I'm happy to take any questions, or if we're out of time, then I'm happy to take questions offline as well. Thank you.
Thank you so much, ma'am. So the session is now open for the question and answers. Kindly drop them in the chat box if you have any questions. We'll just wait for 1 more minute. Yeah, so ma'am, would you like to read me out the questions for you?
Yes, please. Thank you.
So the first question is, what aspects of the arbitration are decided by the law of arbitration agreement?
Great question. So the law of the arbitration agreement decides a contentious area in the actual arbitration, which is how would you interpret the arbitration agreement itself, existence of the arbitration agreement, its validity, whether or not the arbitration agreement is determinative of issues that are arbitrable. All these are decided by the law of the arbitration agreement. And some describe this as threshold issues to even deciding whether or not arbitration is available as a remedy.
So I hope my this answers the question. So hurry up, guys, if you have any questions. Yes. So ma'am, the next question is, there are many debates in seat and venue.
That's true. There are
What is
my
your
whole
opinion on the same?
My whole presentation was about the many debates on seat and venue. It remains a contentious area of law, although I think that it's often the language of the clause that adds to the confusion around the issue. Although courts in their judgments have now tried to delineate these concepts as best possible. One latest judgment that you may have read about is the case that we acted in PASL versus GE Power, where the Supreme Court has even held that Indian parties can now choose a seat outside India. So now, in fact, when you're interpreting the provision saying parties are free to choose any place of arbitration in section 21, I would read that to include a seat outside India as well. But yes, it is an area of great contention.
So ma'am, there is one last question for you. Are there any advantages to keep the law of seat and law of arbitration agreement different? If yes, what are the advantages?
I would say that keeping the law of the seat and the law of the arbitration agreement identical has some advantages, because one, you would have uniformity. Second, typically, if your seat is, say, for example, if it's Singapore and an arbitrator is chosen from that jurisdiction, then there's naturally familiarity in interpreting that specific law. The other way to look at this is that, you know, you choose your arbitration agreement to be governed by the proper law of your contract. So there again, there is another form of uniformity because it follows the law of the main agreement and your interpretation occurs under the same law. So it really depends on both who you represent as the party, who the counterparty is, and what is the likelihood of you being either a claimant or a respondent in the dispute, and what law would be more beneficial to you depending on which party you represent. So for example, if I was representing a foreign party, I would typically want to choose a seat that is more amenable to that foreign party's interests, versus if I were representing a domestic or an Indian party, where the familiarity with, say, a seat in India and Indian courts, and also the process here, or perhaps, you know, even the situs of where the dispute is, could gain relevance. Also, one may want to have considerations of cost, one may want to have considerations of efficiency, and where your witnesses are located, where your parties are located, where your documents are located, because typically arbitrations that are not seated in India can be a fairly expensive process. Although now, of course, we even have a lot of, most of our arbitrations are now online, and, you know, these problems are to that extent mitigated.
So, ma'am, thank you so much. There are other questions also. Due to time constraint, we will be sending you the questions via mail.
No problem.
Later. Thank you.
I'll be happy to answer them.
Now we have come to the end of this lively gathering. Thank you so much, ma'am, for your precious time and willingness to contribute. We're really glad that we could have you with us. It was really an amazing session, and I express my heartfelt gratitude on behalf of our organizing committee, entire law department of JECRC University, amicus curiae, and all the faculties of law to take this opportunity to thank you for giving your valuable insights. It was a very insightful session, and we are indeed grateful for such an enlightenment. Now I would request Dr. Namita Jain, ma'am, Head of Department, JECRC University, to give vote of thanks and felicitate our guest speaker with e-memento as a token of gratitude and honor. Over to you, ma'am.
Thank you, Rupanchi. Thank you, Shalaka ma'am, for accepting our request to be a speaker in this session. And thank you for such an informative and interactive session. Please accept this e-memento as a token of gratitude from the Faculty of Law, JECRC University, and Amicus Curiae, a law club. Thank you so much, ma'am.
Thank you so much, Dr. Jain. Thank you, Rupanchi, and thank you to all of you attending this conference today. And I wish you a good afternoon.
So now I would like to forward this session to Akshat. Over to you.
Good afternoon to all. Now the session is will be taken forward by Ms. Shivani Joshi, student in charge, amicus curiae. Please.
Good afternoon, everyone. I hope every of the participants and guests have joined the session.
Yes, all of them are here. Shivani,
Okay.
You start.
Okay, so as we have already attended 2 sessions before this session, one is on the international perspective of arbitration, and another one which is on conundrum of seats and venue. So let's move forward for the most awaited session, that is on panel discussion. So I, Shivani Joshi, third-year law student and in charge, amicus curiae, JECRC University, take this opportunity to welcome all our panelists, moderator, and spectators to this most awaited panel discussion of National Bootcamp on Performance and Practice of Arbitration. In the new normal, virtual platforms have become an interactive and useful tool by which we can gain invaluable insights from the very best legal minds. We have been privileged to have this stellar panel of speakers with us today who have been very kind enough to spare some time from their invaluable schedule and to impart their wealth of immense knowledge and experiences. We are immensely grateful to the honorable panelists for being with us today. Our panel do not need any introduction to anyone who is practicing in arbitration law, otherwise following the developments of the same. But still, I would like to introduce all our panelists. So, to engage in a panel discussion on laws governing three major arbitration seats, that is London, Singapore, and India, we have three different panelists, and from London, I would like to welcome Mr. Aaron Darling Hoshe. Sir is a barrister, adjudicator, and arbitrator mediator practicing from Law Library, Dublin, and 4 to 5 Gray's Inn Square in London. He is also a part-time law lecturer at Robert Jordan University, teaching on their LLM in construction and arbitration. He has co-authored 3 editions of textbook Arbitration Law. He has been the co-editor of the Construction, Engineering and Energy Law Journal of Ireland since 2015. Aaron is a member of a number of legal construction and ADR committees in London, including the Council of the Society of Construction Law, Board of Trustees of the Chartered Institution of Arbitrators, and the Committee of Adjudication Society. So I welcome you here and thank you for sparing the time from your Sunday morning. It's early 9 a.m. there. So good morning.
Thank you. Good morning and good afternoon to you.
Thank you, sir. Welcome, sir. And moving forward to our guest from Singapore, Mr. Anthony Sher Nicholas. Sir is a dual qualified international dispute resolution lawyer who is regularly engaged as counsel, arbitrator, or mediator from commercial disputes. Sir is admitted to the SIAC's Reserve Panel of Arbitration and wrote the arbitral rules of Bihai in Asia International Arbitration Center. He is also a mediator with the Singapore International Mediation Institute and sits on committees of Singapore Law Society and international law associations. In addition to his legal practice, Anthony Sir is a law lecturer at the National University of Management in Panama. He has delivered various academic seminars internationally. His academic publications cover a wide range of dispute resolution topics and have been awarded prizes by the Singapore Law Society and YSIAC. So I welcome you here.
Thanks very much, Shivani. It's a pleasure to be here.
And moving forward to our last panelist, Mr. Tejas Karya. Sir is a partner in head arbitration at Shardul Amarchand Mangaldas. He specializes in international and domestic commercial arbitrations in commercial mediations. He has represented multinational and Indian corporations as counsel in ad hoc institutions, arbitrations, and also sits as an arbitrator. He was involved in drafting 2015 amendments to the Indian Arbitration Act. He is fellow of CIAB India and Indian Administration Forum. He is recognized as global leaders by Who's Who Legal, leading lawyer in dispute resolution by Asia Law Leading Lawyers, leading individual by Legal 500 rank and band. 2 for arbitration by Chambers and Partners, and litigation star by Benchmark Litigation. Sir is a member of SIAC Court of Arbitrations Governing Council of Indian Law Society, ICC Commissions or Arbitration in ADR, and Vice Chairman of SCL India. He has co-authored number of publications and extensively spoken on arbitration and mediation. So I welcome you here for the panel discussion.
Thank you, Shivani. Good afternoon, all.
Good afternoon, sir. And moving forward to our moderator of the session, who is also our event director, Mr. Samir Shah, sir, the very person who has guided and motivated us throughout this event. Mr. Shah is director at CIAB India branch and founder and proprietor at SU Shah and Associates, having its main office at Ahmedabad and associates in Pan India and overseas. Sir is having 25 plus years of active legal practice and a special focus on ADR, especially in the field of arbitration and mediation. Sir is a steering committee member and co-chair of Asia Pacific region of Green and Arbitration. He is a committee member of Bihai Asia International Arbitration Center. Singapore. He has been recently appointed as a co-founder of India chapter of engineering of energy-related arbitration practitioners. Sir, I welcome you.
Thank you, Shivani, for those brief introductions of all the esteemed panel members and myself. Very good afternoon to all the participants, and good morning to you, Aaron. And good afternoon to, I think it would be good evening for you, Anthony, I suppose, in Singapore. And good afternoon to you, Tejas bhai. Are we good to go?
Yes, sir.
Yes, sir.
All right. Okay. Thank you. So you see, in 1.5 days, what has been told by Shivani is that the participants have gone through the basics of arbitration so far as the concepts are concerned, different modes of arbitration are concerned, a brief history and overview of the Indian arbitration law as such, and also the procedural aspect of the domestic arbitration in India. There was also a session on drafting of arbitration agreement, and today another session, the last session was another important topic of the conundrum between seat and venue, which is equally, faced by both in international and domestic arbitration across different jurisdictions. And also you went through the international perspective of arbitration. Now, having now, understood the broader picture of arbitration, let us now dwell a little further and try to understand this topic or this subject a little bit more from different jurisdictional perspective. And that is why we have invited the esteemed panelists today from 3 different jurisdictions, London, of course, being the hub and leader in international arbitration. Singapore, of course, catching very fast with London, and India is one of the most evolving jurisdictions to come to look for in future. So having said that, let me just start this discussion. You see, since we have, yesterday, as you have already gone through the brief history of the Indian law of arbitration, may I invite you, Aaron, to just quickly have a brief overview of how the law have evolved over the period of time in so far as London is concerned, and then same for you, Anthony, so far as Singapore is concerned. If you just can just quickly lead us through the how the law has developed over the period of time so far as arbitration is concerned.
The legislation in London is the 1996 Arbitration Act, which has some similarities to anti-trial model law jurisdictions, but is also different. So it's difficult to say in any one country when there might be a pressure to amend that legislation, but it's not something that you would necessarily think would happen in London anytime soon. So the legislation is obviously interpreted by the decisions of the courts in London. So I mean that's a very short overview of the legislative framework.
So likewise in Singapore, a lot of the arbitration law in Singapore was based on the Old English common law. Obviously, as a former colony, we adopted many of the case law as well as the basic statutes. In Singapore, over time, the legislation is really split into 2 separate branches. So for international arbitrations, which I typically deal with, we have the International Arbitration Act. And this is like India's arbitration law. It's based on the anti-trial model law, and generally speaking applies whenever the dispute is of an international nature. But by contrast, there's also the Domestic Arbitration Act, which applies where there are just two Singaporean parties or where there's no international link to the case. So generally speaking, these two pieces of legislation are really quite separate. Though of course there are certain instances where there are overlaps. One big difference, for example, is that with the Domestic Arbitration Act, there's a possibility of having an appeal on a point of law, whereas in the International Arbitration Act, because it's close to the model, it's basically the model law. There's this option doesn't exist yet. So that's sort of the framework in terms of legislation. But of course, as with most common law countries, that the real substance of Singapore law comes from its case law. And obviously this is changing all the time with developments from the Court of Appeal, which touch on one area or another.
Thank you, Aaron and Anthony, for making us letting us know about the brief overview of the law, which is right now applicable so far in jurisdictions are concerned. That takes me to a next question, and one about the system as such, so far as India in particular is concerned. So if I ask you, Tejas Bhai, you see, we have always, majority of the arbitration in India is ad hoc. They are private, they are not institutional, unlike in London or in Singapore. So what do you think is, is it good or is it bad? And what should India do? Should we just blindly follow the institutional system as in other jurisdictions like London, Singapore, or there has to be some fair balances, or what is your view on that?
Sure, thank you. Yes, so institutional and versus ad hoc has always been a debate in India, which is not in other jurisdictions. If we compare India, we are uniquely positioned because traditionally what has happened is that we rely more on ad hoc arbitration as compared to the institutional arbitration. And there are various reasons for that. One of the reasons is that we perceive institutional arbitration as a more expensive way to do arbitration. Second is we don't have institutions like LCIA, what we have in London, and SIAC in Singapore. So we have institutions in India. We have now Mumbai Center for International Arbitration in Mumbai. And in Delhi, we have Delhi International Arbitration Center and Indian Council of Arbitration. But they have not taken off the way the other international institutions like ICC, LCIA, and SIAC have done a great job. And it helps a lot to have a strong institutional presence. And we realized that in 2015 amendments, as well as in 2019, we had a second round of amendments, as you all know, where we have tried to incorporate a lot of best practices to bring India at par in terms of institutional arbitration. And institutional arbitration has, of course, a lot of advantages. The first advantage is advantage of institutional arbitration. It has its own set of rules, and those rules provide step-by-step guide to conduct the arbitrations. And that is very helpful because no matter what we do, the ad hoc arbitrations, the arbitrators decide their own procedure as per the Arbitration and Conciliation Act. And we see the Arbitration and Conciliation Act, which is based on the UNCITRAL model law, provides a broad framework of conducting arbitration. Of course, it's a complete code in itself, but not all the procedural steps are laid down under the Arbitration Act. So that's why these institutional rules play a major role. You have UNCITRAL rules also, which you can adopt for ad hoc arbitration, or we can go for an institutional rules. It has a set timelines. It has all the elements with regard to the appointment of an arbitrator. We ensure that the arbitrators are independent and impartial. So it's a job of an institution to ensure that the arbitrators are either from the panel who have no conflict of interest. Then secondly, if any challenge has to the arbitrator has to be made, the institution is the final authority as far as the appointment of an arbitrator is concerned. So that takes away a lot of burden from the court under Section 11, if you know, under the Arbitration Act, for appointment of an arbitrator. So with 2019 amendments, what we have done is courts will delegate or the appointment process to the arbitral institutions, and that would be accredited and designated by the courts who are authorized to appoint the arbitrators. Apart from them, the institutions also provide the fund holding facilities. So all the costs are taken in advance, and arbitrators are paid fees from the advances which the institution has received. So we don't have to pay to the individual arbitrators. The institutions also provide a administrative support for conducting hearings, and they have the secretariat. So every matter they have a counsel or an in-house case manager who takes care of all the procedural aspects. In terms of award, once the award comes, they also provide the facility of scrutiny of the award, and that is very helpful. Although they don't change the content of the award, but scrutiny helps a lot to ensure that there are no typographical errors, or not that the awards are deciding something which is not referred to, or something which is missed out. So those are the aspects are very helpful for the institutional arbitration. The other advantage of institutional arbitration is emergency arbitrator. Now, for getting interim measures before constitution of the arbitral tribunal, we go to court, and it takes a lot of time in the court process, and section 9, we lose the confidentiality aspect of the arbitration, because once the matter goes into the court, the confidentiality is lost because we are fighting in open court. Whereas emergency arbitrator is appointed in less than 48 hours, and an emergency arbitrator decides the interim measures in 14 days. All major institutions provide for that. Of course, we had tried to amend our act twice for recognition of emergency arbitrator in 2015 and in 2019, but that has not come through. But by way of a judicial pronouncement and otherwise, all our institutions are providing the benefit of emergency arbitrator. Other thing which we have seen, and as a member of the court of SIAC, we decide this application for consolidation. So if you have multiple contracts or multi-party contracts, what we get an advantage of an institutional arbitration is that a common tribunal can decide all those matters, and we have seen it in construction contracts. You have back-to-back contracts, or there are subcontracts arising out of the main contract, and instead of having separate arbitrations, the arbitrations arising out of the same relationship and the cause of action can be consolidated, and that is also an advantage of institutional arbitration. Consolidation is not available under the Arbitration Act. There are some judgments where the Delhi High Court have said that if parties are same and contracts are different, but the issues are common, then the arbitrator should be appointed. The same arbitrator should be appointed, or so that the arbitrations are consolidated, or there is no multiplicity of proceedings or contradictory awards. So those are the advantage of institutional arbitration. So in my view, clearly institutional arbitration has an edge over the ad hoc arbitration. In institutional arbitration, on day one, we know what is the cost of the whole arbitration. So we have the cost calculator on most of the institutional websites. So you put the amount in dispute, you get to know the cost, and on an average, we have seen that the arbitrations are quite efficient when it is conducted by institutions as compared to ad hoc arbitrations. So Samin, in my view, I would definitely recommend that India should move towards institutional arbitration. We are having more and more institutions where the arbitration is conducted in the most efficient way. But we have a long way to go, and in next 5 years, I'm very confident that we would move more towards institutional arbitration as compared to ad hoc arbitration.
Just a follow-up to what you just mentioned about, I mean, so much advantage in an institutional arbitration in comparison with an ad hoc. Then what actually is stopping our country to adopt to institutional arbitration? I mean, having so much advantage, is there an issue of the mindset of the stakeholders, many issues, or I mean, so far as the legislation, the law is concerned, it has now been, I mean, amended to be at par with the international system as such. So what actually is stopping us from adopting institutional arbitration?
I would say lack of awareness, because many times when we are drafting our contract, we don't include institution arbitration because we are not aware of the advantages of that. That's number one. Second is, even if you are aware, then we feel that it will be expensive institution if we have to select an institution from Singapore or London. So that is the or ICC. But we have seen now even 2 Indian parties are selecting CIAC arbitration or ICC arbitration, and it's not that expensive. So that is the mindset difference. And the other is also retaining control. People want to retain control over the arbitration process, because many times they want to, because Arbitration Act says that unless otherwise agreed by the parties. So they want to have control over the procedure, whereas in institutional arbitration, you have to follow the rules. But if we compare the two, of course, as you rightly agreed, that that has the more advantage than ad hoc arbitration. And we have now seen in last 6 years more inclination towards institutional arbitration, because even public sector undertakings and governments are now going for institutional arbitration. So that is the future, and we have to, because when we go outside, when the seat of arbitration is outside India, invariably it's institutional arbitration. It's the only problem when the seat is in India. So at that stage, we have to now start relying either on the Indian institutions or have the outside of India institutions, because ICC, CIAC, and LCIA, all three of them are very, very active in India. And they're very well known now also to the people who are drafting the arbitration agreements. So drafting of arbitration is key, because nobody agrees to an institution when the dispute arises. The institution should be incorporated at the time of drafting itself. And that is where we all need to change. And you are the future generation and the present generation of arbitration lawyers who have to keep that in mind when you draft or you are advising your clients. You would have to ensure that you at least suggest institutional arbitration. Let them reject it, but at least suggestion should be made. Now, most of the time, parties don't even have the benefit of considering institution arbitration because they are not advised accordingly. So that's my view. The reason is that we have always seen international commercial arbitration. We have seen institution, but in domestic, we don't see institution, which we need to now start incorporating.
Thank you, Tejas Bhai, for that very insightful, reply to this issue of institutional versus ad hoc. As an offshoot to that, Aaron, if I may ask you, what impression, and that's a fact, in fact, that majority of arbitrations in London or in Singapore are institutional. So is it the case that you don't have any ad hoc arbitration, or what is the situation, and how does it go about? How does ad hoc arbitrations are playing in London?
It depends on the nature of the industry and which the dispute has arisen. So in some instances, there will not be an existing dispute clause that governs the pathway after the dispute is triggered. So as already been said a moment ago, once there is a dispute, it's very difficult for the parties to agree on just about anything. So getting the parties to agree to use one institution that one side might favour over another institution that the counterparty wishes to use could be a very tricky issue to navigate. Whereas both parties might agree that it's in their interests to arbitrate rather than go to court. So in those situations, an ad hoc process might be used. So it really sort of depends on the circumstances. Those who've used institutional arbitration before and used it successfully and haven't formed the view that it can be too rigid and too expensive, they're going to be comfortable with that. And the likelihood that they would want to use an ad hoc arbitration mightn't be that high. Whereas conversely, anybody who's had a successful experience with an ad hoc arbitration could think, I don't want to be involved in an institutional dispute. So it's sort of hard in any one city or jurisdiction to give a universally applicable response to that issue. There are advantages and disadvantages to either method. Arguably, if you're concerned about a counterparty behaving badly, it could be that the institutional arbitration gives you better protection there. So somebody might look to disrupt the process in an ad hoc arbitration, whereas in an institutional arbitration, they might think, hang on a minute, I'm a medium to large size company, I'm going to be arbitrating again, and I don't want any idea going around the secretariat or the executive of this institution that my company's troubled, so I better behave.
Thank you, Aaron. Anthony, what are your views? I mean, do you think that there are certain advantages in ad hoc as compared to institutional arbitration? And what is the position in Singapore?
Yes, absolutely. I mean, I would start off by picking up on many of the comments that Tejas and Aaron have both made. Firstly, being that actually the discussion and the considerations that Tejas was mentioning actually apply in many other jurisdictions as well. So, I mean, I do quite a lot of work in Indonesia and in Cambodia. And again, sometimes it's, parties are just naturally cost conscious. They consider whatever is foreign, whatever they don't know to be naturally more expensive. Now that's not always the case. But as a result of this sort of belief that foreign arbitration is more expensive arbitration, parties will intentionally choose domestic arbitration instead. Having said that, the key really is about drafting. And again, this is another point that Tejas mentioned, which is that generally speaking, when you have a contract and where parties are of a certain level of sophistication, whereby they're getting advice on how to draft a dispute resolution clause, quite often corporate lawyers, they just don't know this debate that we're even having. What they'll do is they will take a precedent from one of their colleagues, from one of the earlier contracts, and just copy paste it. And so sometimes it becomes a Frankenstein document whereby you have something which starts off with Indian arbitration, but then maybe they've heard from somebody about something about Singapore. So then maybe part of the clause gets amended slightly to include SIAC, and then part of the clause remains this. And so you have basically a whole mess. So it's really, again, as Tejas was saying, on the next generation of lawyers, which is you guys, to be able to really understand how to draft these things, how to incorporate them into your contracts properly, so that when you as the corporate lawyer or when your colleagues as the dispute lawyers have to deal with these types of arbitrations, you have something sensible to work with, not just this complete mess. Now, Samir, on your question about, well, are there some instances where it makes sense to have ad hoc non-institutional arbitration as opposed to institutional arbitration? I would say yes, there are, though they are rare. And again, it comes back to something which was discussed earlier on today about who do you represent? What is the interest you're trying to protect here? So again, I've seen arbitration, in Indian-related arbitrations, where I've actually advised the client to not include institutional arbitration. And the reason why is because I wanted to try and frustrate the other side if they want to sue, which means that if I were to choose, let's say, SIAC arbitration, where it's very, under the expedited procedure, whereby the party who is likely to sue would want to, would start proceedings and would go along that procedure very quickly. It wasn't in that case in my client's advantage to resolve the dispute quickly. It was in my client's interest to drag this out as long as possible, so that we could find ways to frustrate the other side, and therefore, sort of gain that commercial advantage. So there are instances where it makes sense to not choose what is, generally speaking, the more efficient institutional arbitration, but they'll be quite limited, and it'll be really quite specific to the facts of your case. Again, as a general rule, if you're a corporate lawyer and if you're looking at a contract, the general rule is you would want to choose institutional arbitration if you're not really sure who's going to be sued.
Thank you, Anthony. Just taking one pick from this discussion, it seems that one of the major concern or the major reason in this issue is cost. And Tejas bhai, if I just ask you on that part, what do you think that the incorporation of Schedule 4 structure of fees in the Act in India, has it played, has it played any role beneficial on this aspect of cost?
Some arbitrations, yes, because the arbitrators follow Schedule 4, but many arbitrators are not following Schedule 4. So that has not brought in the result as was anticipated. But it has at least brought in some kind of sense of responsibility where earlier the arbitrators were charging per hearing or per session. Even if there are 2 sessions in one day, they would charge double the fees. Which has reduced now with the Schedule 4. But all that is not necessary. In my view, institutional rules have the schedule of fees. You exactly know what total fees would be if you are going to have an arbitration with institution. LCI has hourly fees, but again, those are quite reasonable fees of the arbitrators, and depending on the nature of the dispute and the amount involved in the dispute, the institutions choose the arbitrators. So there are panels like in CIAC has reserve panel, main panel. So if there are small disputes, they appoint the young professionals as the arbitrators. And that's the advantage of institutional arbitration rather than going to, with due respect, all due respect, former judges of High Court and Supreme Court. There are so many lawyers and practitioners who can be considered as an appointed an arbitrator through the institution. So that is the future. Once this Arbitration Council of India comes into effect and the section 11 is also notified, the amendments to 11.3 and 6, then we will have institutions appointing the arbitrators, and that may not be always former judges of High Court and Supreme Court. So that would bring in a lot of streamlining in terms of reducing the cost. As of now, we are having this issue with regard to the ad hoc arbitrations and the arbitrators deciding their own fees. And many times you don't want to antagonize the arbitrators by saying that we will not pay the fees determined by you. And that's the dilemma always we feel, that when the arbitrator says, I will have a reading fees, I will have award writing fees, I will have a session-wise fees, and sometimes we wonder whether they're going to have a thinking fees also. So that is something we always wonder, is that how many kinds of fees we have to pay to arbitrators, whereas an institution is straight, like you put the amount in dispute, there is a fee calculator and you know the fees. So sometimes we have also seen that parties have settled because they know exactly how much the arbitration is going to cost. So they do the cost benefit analysis and see that, look, if I have to spend this much in arbitration, then have an award, enforce the award, and if I'm getting say 30% less, let's settle. So that's the certainty we get in institutional arbitration, and the Schedule 4 and all. Many times good arbitrators are not able to follow because the effort in resolving the dispute is completely outweighs the fees which are there. Because if the amount is in dispute is in crores and you are getting paid only 30 lakhs as the total fees for the entire arbitrations, many arbitrators don't want to do that. So there has to be a balance. Sometimes you are overcharging. Sometimes if you follow Schedule 4, you get paid less. So the best approach is to go by the institution and go by the schedule of fees, where everybody is happy and everybody is clear with regard to the cost of arbitration.
If I may just pick up a very quick point.
Yes, please. Yes, Anthony. Yes, please.
Thanks, Samir. So something Tejas just mentioned actually reminded me of a former case that I worked on. So I was assisting my boss at the time, who was a former High Court judge, and he was sitting with from Singapore. He was sitting with 2 Indian Supreme Court judges on a very, very large Indian case. And one of the former Supreme Court judges was the chairman. Now, admittedly, this was a very big case, hundreds of millions of dollars in dispute. But by the time I was working on this case, I think the tribunal had already issued like 7 or 8 procedural orders, and they hadn't even gotten to jurisdiction. Now, for the students in the audience, generally speaking, when you have a case, you'll have maybe 2 or 3 procedural orders for the entirety of the arbitration. for this particular case, they had been through so many rounds of discussions and sort of debates, writing submissions. And from the tribunal's perspective, it was fantastic because they could just keep on billing and billing and billing. And what that means is that they could charge, $1,000 per hour just to sit on this case. And, that if the parties want to keep on fighting, it means that the Supreme Court judges, the tribunal members just keep on billing and they make more money. So again, it works out really, really well if you're part of that older generation whereby you can get these sort of like hourly fees and, you just sit there. It doesn't work out so well for the parties because, it's very, very hard to say to the person who's going to resolve your dispute, can you just chill out on your billings? Can you try and be a bit more reasonable? Imagine saying that to somebody. Like, what's the impression that you're going to give to them? They're not going to rule in your favor. They're not going to be particularly happy. So parties inevitably end up just sitting back and saying, okay, sure, bill another 2 million for the case. I'm fine with that, but let's move on a little bit. Anyway.
Thank you, Anthony, for sharing that experience, and that definitely will be helpful for the participants to understand this issue. Now, let's moving a little forward, and I again come back to you, Anthony, because you mentioned something about the two separate laws, one for domestic and other for international arbitration in Singapore, and the regime of appeal mechanism inbuilt in that. So could you just a little bit explain more on and about this appeal mechanism, and what do you think? Does it actually helps the system as such, or there should be some reforms to be made in this whole process?
Yeah, thanks, Samir. So again, in Singapore, there's the domestic track, then there's the international track. The domestic track really being considered as an alternative to the local courts, and the international arbitration track being, I guess, a slightly different creature. Now, Aaron can comment a lot better on the 1996 English Act, but certainly under the Singapore Domestic Arbitration Act, it's a fairly narrow scope of appeal. It's wider than your grounds for setting aside or refusing enforcement of an international award, but it's still ultimately on a question of law which has arisen in the case. There have actually been people asking in recent years whether we should change the International Arbitration Act and actually allow appeals on questions of law for international arbitrations. So I think in 2019 there was some sort of survey about this, and the conclusion was that, well, probably we should have this right, but in practice, nothing's changed. So Singapore remains, I guess, in line with most pro-arbitration jurisdictions, whereby this appeal on a question of law is only available for domestic cases, and I don't think that's really going to change anytime soon.
Aaron, if you can also give your views from the London's perspective on this aspect of the appeal mechanism in arbitration.
The actual appeal mechanism under the 1996 Act is Section 69. So there are two related parts of the Act which aren't appeals as such, Section 67, Section 68. So conscious of the limited time we have today and the other topics we're going to go through, I'll only focus on Section 69, the actual appeal. Well, the parties can agree to take it off the table. So if you're a commercial entity, you've got possibly in-house lawyers, external legal advisors, you've maybe been in an arbitration before, there's a strong likelihood that you're going to exclude that from being a path that everybody can go down. But in any event, where it's possible for there to be a Section 69, because of the jurisprudence of the courts over the last 25 years, most people, I'd suggest, know that the hurdle is very high. That there's many years in the last 5 years where there have been no successful Section 69 appeals, and the total number of cases brought, you're talking 15 to 20 a year which when you allow for the size of the jurisdiction is not very many at all. So it's quite a limited area for somebody who thinks the arbitration has gone wrong to grab at. So an appeal on a point of law that may, in some instances, be excluded by agreement between the parties, that has a fairly low chance of being successful. So there are other jurisdictions where you know there is no allowance for an appeal. So next door to London and Dublin, there's no possibility in Dublin of bringing an appeal against an award. So the backdrop in some of those jurisdictions was perhaps before they reformed their legislation, people went off to the court to try and interfere with the arbitration awards that didn't go as they would like. And then whatever happened at the court of first instance, they would appeal. So you have the potential scenario in some jurisdictions where the award can be appended for 5 years, a first instance review by a high court judge and then an appeal. So in London, you don't have that possibility. It's all very tight. There's 25 years where people know the jurisprudence under Section 69. Few people bring appeals, and of those that bring appeals, very few of those are successful. Thank you.
Thank you, Aaron. From Indian perspective, we know, I mean, Section 34 challenge, though there are limited grounds, but still we have seen so many, challenges happening, and thanks to the jurisdictional delays, the successful party has to still wait for years to get the real, recovery so far as commercial arbitration is concerned. So, what do you think? Is there a need for still further reforms in this mechanism? Because we have, even with, talking of non-metros cities, the challenge will go to a district court, then to high court, and to the Supreme Court. So do you think we need to have we still need some reform, at least in those grounds in Section 34, or at least this 3-tier challenge mechanism in our country?
Sure. So we don't have appeal mechanism, but we have the application for setting aside of an award. And although we don't have an appeal, that power given to the court has been quite widely, if I may use the word, misused by the courts, because what has happened is that the grounds which are there for setting aside the award are quite limited. And those are mostly procedural grounds. And there was one ground which was there against public policy of India, and that has been expanded over a period of time by the judicial pronouncement to also include patent illegality, and then it is worse than appeal. So although in Singapore and London we have the appeal, but as both Aaron and Anthony have said, that it's not used by everybody. I have done number of arbitrations in London and Singapore, and out of this, I have not challenged even a single award. And I think I have done more number of arbitrations in India, and I have challenged each and every award passed in India. So that is the difference between London, Singapore, and India, is that the mindset of party who has been unsuccessful in the arbitration is to challenge the award. Although there is no appeal. Imagine this would have been appeal, then you can also challenge the award on the question of facts and also appreciation of evidence. But that is not the case, but Indian courts have exercised the excessive jurisdiction. To curb that, in 2015, we have defined by way of an explanation what is the meaning of public policy. Under Section 34(2)(a), we have given the patent illegality ground only for domestic arbitrations. Under Section 36, we have made a compulsory deposit if you are asking for a stay of the enforcement. Earlier, there was an automatic stay that has now been removed by way of an amendment, so that if you want to stay the enforcement of an award while the application for setting aside of the award has been pending, you have to make a deposit or give a security if there is a money award. So that has brought in also a lot of changes in the mindset of people who used to challenge the award as a drop of the hat. Now they are thinking twice. In Singapore, many times client asked that should we challenge the award? I said, are you ready to pay the security for the cost for the other side? And those costs are really heavy and actual costs in Singapore and London. So many times we comply with the award rather than challenging the award. And here in India, we don't get the actual cost. And as you rightly pointed out, the Section 34 is also, the time limit is 1 year. I have never seen a single Section 34 getting decided within 1 year. Although we have changed the definition of the code under Section 21E and under Section 47 for foreign awards enforcement and challenge of the international commercial arbitration, we have to now can go directly to the High Court. Now, under the Commercial Courts Act, the High Court has a commercial division and commercial appellate division. And all those judges are also quite busy because we don't have specialist court. Like in London and Singapore, there is a specialist commercial courts. Although we have the Commercial Courts Act, our commercial court judges are also handling other matters. And that is where the problem is. And sometimes this Section 34 or the appeal under Section 37 against the order of 34 goes in a black hole. Like in Gujarat High Court, I remember I filed a appeal against Section 34 order under Section 37, and there was no special category for that. So they categorized that as a second appeal. Now the second appeal is under Section 100, which is only on question of law, and that takes 10 years in India to get decided. So you are successful in arbitration, you are successful in challenge of the award, you have an enforceable award, but because there is a provision of appeal against that order, you are not able to get the fruits of the award. So I completely agree. The only thing which we need to change is the mindset of the court, have a specialist court and judges who can decide these appeals very, very quickly. For example, appeal against the order rejecting setting aside has to be decided, because if the grounds for setting aside is limited, how can a ground to review that order under appeal can be broader than that? So it has to be narrower than that. There are a number of judgments to that effect, but we need to implement it. And we have won arbitrations in 2010, 11, and still some of the proceedings are still pending in the court. And when we come to the enforcement under Section 36, what happens is that you have to go under CPC, because the award becomes a decree of the Indian court, and then CPC Order 21 would be applicable. And that again is a code in itself to enforce the award. So we need to completely overhaul this second leg of the arbitration. Arbitration, of course, we need to fix it, and we are fixing it. But we need to fix the other part, and some courts are doing extremely good, and some courts need some improvement in terms of timelines, is to reduce the timeline to have the scrutiny of the award or any appeal under Section 37 should be reduced, and we should then go for enforcement of the award as early as possible.
Very, very rightly said, Tejasbhai. I mean, we really need those drastic mindset changes, both from the bar and the bench as well as the beneficiaries, to at least realize the objectives behind Arbitration Act as such, and conducting an arbitration rather than going to a court. So now let's go a little back. I mean, as I mentioned that we had a very interesting session on the conundrum between seat and venue, and therefore picking up from there, and just what we discussed earlier on so far as drafting of the arbitration agreement is concerned. Tejasbhai, if I ask you, what would be the main consideration of when you select a seat, according to you?
Yes, I think there was a previous session and I joined 10 minutes early, and a lot of you had questions on surrounding that. And there was one question also asked to the speaker, is that how do you select the seat? And in my view, you select the seat depending on the nationality of the parties. which is the governing law between the two parties. In the sense, are you selecting a governing law of one of the parties or completely neutral governing law of the main contract? Of course, the law of the seat will be applicable in any case because that's a lex arbitrate, that's a curial law. So, for example, if you have a seat of arbitration in Singapore, the Singapore International Arbitration Act, there are two arbitration acts. So, the Singapore one with International Arbitration Act will be applicable if the parties are from two different jurisdictions. And that you can't avoid. So the seat leads to the jurisdiction of the court. So if you have a seat in London, then English courts will have jurisdiction. If you have a seat in Singapore, Singapore courts will have jurisdiction. You can't have seat as India. You have to have a city in India. We always compare India with Singapore, but Singapore is a city state, and India is a country. So we can't have comparison. And we are always trying to make India as the hub and India as a seat of arbitration. That can never happen. We have to identify particular locations in India, say Delhi, Mumbai, Bangalore, Chennai, Hyderabad. You can select any of them. And we have to develop the whole ecosystem around the arbitration on those places and ensure that those are the preferred seat of arbitration. So when selecting a seat, only thing which you need to keep in mind is that what is the attitude of the courts at the seat, number one. Number two, the nationality of the parties. Third is where your enforcement is going to be, because if you are going to enforce the award in other jurisdiction, you always need to have a New York Convention seat because that is where your enforcement becomes easier. And the third is interim measures. When do you want to protect the subject matter of arbitration? Fourth is that if you don't protect the subject matter during the pendency of the arbitration, you may end up with a paper award. What's the use of that if you have not protected the interim relief? So seat has to be carefully chosen, and whenever we select the seat, we have to also select the institutional rules which are very near to that seat. So, for example, always we have seen in experience is that if we are selecting London for some reason, we go to LCIA rules, which are equally good. You can have CR rule also in London. No, there's no prohibition in that, but it always is easier to go to the body of rules which are of the institution which is located in that particular seat. So those are the things we have to keep it in mind. There is no set formula, but you have to have permutation combination of various facts and try to ensure that which is the best seat available for you.
Thank you, Tejas bhai. Adam, would you like to add to what Tejas bhai just mentioned about the seat selection criteria?
Apologies, I was muted. Sorry. There's various institutional guidelines on the factors that can assist in picking a seat. So dating back about 5 years ago, the Chartered Institute of Arbitrators published what they called the London Principles. So I think one issue is to be conscious of the fact that the strength or safety that you might think would apply in a seat can change, albeit it will change slowly, but it will change. So in certain instances, if a particular law firm or a company had been involved in an arbitration 10 or 15 years ago, it would be unwise to think that everything is the same as it once was. There is change, albeit slowly. The other issues that perhaps haven't maybe been discussed or discussed in any great depth are you'd have to have regard to the quality of the local judiciary if that became an issue. So what else would we need to look at? The accessibility of the seat. I can't think off the top of my head where you cannot get a direct flight from London, but there are certain countries where it's not possible to fly directly to another country. You have to fly somewhere else on the way, and of course, obviously, I'm overlooking the fact that we're still dealing with predominantly virtual hearings and the issues thrown up by the pandemic. And lastly, again, being conscious of time, the facilities in the city that the seat is located in is there a modern equivalent of Maxwell Chambers, whatever it might be? So are there good internet connections and so on? So those are some of my thoughts on the issue. Thanks.
Thank you, Aaron. Tejas, just coming back on that, what do you think goes behind the mindset of those who are drafting the arbitration agreement, normally the in-house counsel or maybe the external lawyers, so far as selecting Singapore, I mean, from the Indian perspective, as a seat and not Hong Kong? Because if we compare the two, I mean, distance-wise, both the places are same. In fact, Hong Kong, if we look from the exchange perspective, is much cheaper than Singapore. There is ease of travel because you don't have to, as Indians, we don't have to get a visa to visit Hong Kong, and so on and so forth. But still, in spite of these ease and advantage, I mean, the advantages, Indian parties are still selecting Singapore. What are the reasons for that?
I would say a couple of reasons are there. One is the Singapore courts are quite pro-arbitration. So if you want to have a less intervention from the courts, Singapore has been very, very good in that. You have HKIAC in Hong Kong, but SIAC in Singapore. But SIAC has been more prominent than HKIAC, although HKIAC is doing very well in terms of an institution. Other apprehension Indian parties have is that the overhang of Chinese control over Hong Kong. And many times we have seen that whenever we have contract with Chinese entities, they prefer Hong Kong than Singapore.
Tejas bhai, sorry, just to interrupt you, there is a very interesting information I wanted to share at this particular point, because you raised this issue of Chinese influence. Sometimes, I mean, a few years back, I just was discussing with one arbitrator in Hong Kong, and we just discussed on this particular aspect itself. And what it was found, I mean, from the data, that there are more Chinese or origin judges in Singapore than in Hong Kong.
Yes.
So how far this perception of the
perception,
yes,
you're absolutely right. So problem is that you don't realize when you have Koreans and Chinese in Singapore, because Singapore is quite cosmopolitan in that sense, and Anthony is better placed than me to comment on that. But what I have seen personally is that Singapore has a very wide range of the legal support in terms of law firms, in terms of independent arbitrators. You have barristers' chambers there, and in terms of infrastructure, it's very well placed than as compared to Hong Kong. And you have a lot of Indian, South Indian community also there. So you feel more connected to Singapore than Hong Kong. So those are the perception, and there is no real answer to this, because both are equally situated, both are equally good, but it's just that one is more preferred than the other.
So Anthony, now I think feeling proud and elated listening to this, what do you have to say? Why you think, I mean, parties are preferring Singapore, and now Singapore, of course, is leading in a race so far as the Asian arbitration institutions are concerned?
Yeah, I think Tejas really hit the nail on the head just now, which is that a lot of it comes down to the SIAC and simply down to marketing. I think the SIAC has done a phenomenal job of promoting its services overseas in some of the key jurisdictions nearby, India, Indonesia, Philippines, all of which are very big users of SIAC arbitration. As Tejas was also mentioning, there's this hangover, this idea that mainland China has a lot of influence in Hong Kong, and indeed that's increasingly becoming the case, which is fantastic for us in Singapore, because it means that all of the work now flows over here. To what extent does that realistically affect the Hong Kong judiciary and Hong Kong seated arbitrations? Probably not very much for the next 2, 3, 4, 5 years. But if you have a long-term oil and gas contract whereby you have, a 30-year duration, a 30-year term, and you're dealing with an SOE, a state-owned enterprise linked to China, maybe you don't want to have it seated in Hong Kong, your arbitration seats in Hong Kong anymore. maybe you do want to move it to Singapore for just to alleviate any sort of fears that you have about the long-term independence of Hong Kong. Again, frankly, I don't think that's for most Singapore arbitration practitioners. I don't think that the general opinion is that Hong Kong is a bad seat. It's of course a very, very good alternative to Singapore. But again, sure, if you want to come and arbitrate over here, we very much welcome you to do so.
So yes, thank you, Anthony. I think, Sen, what it boils down to that apart from the considerations which you all just mentioned, I think the neutrality of that particular jurisdiction and the fairness of procedure is what goes behind the mind of those who are drafting and selecting the seat for that matter. Now let's go a little further, and when we touch upon the court processes on different issue of different jurisdictions. Aaron, if I can start with you from the English point of view, because that is what has been followed both by India and Singapore. What views the court would have and court you have taken if an arbitration award is set aside at the place of arbitration, at the seat, by the seat court? How does the court views that in England?
Apologies, I keep having myself muted. Sorry about that. The starting point is that would be respected. So that's the starting point in terms of the international relationship between courts and making everyone's life generally easier, so as not to overly complicate how we conduct our legal work. But there are exceptions to that. So in certain instances, if it can be argued or found that the decision to annul is contrary to principles of natural justice or domestic public policy, the annulment will not be respected. So I'm not sure that I want to go in to the case law on that, if that's okay. It's basically scenarios where a judge in London has said that a particular jurisdiction is one where the judges can be manipulated or held to account, such that the decision isn't a bona fide one. So the basic starting principle is to respect the annulment, but in certain situations, if it's seen to be suspicious or it wouldn't stand up to close analysis, and there's a belief that there's been some sort of interference in the judicial process, which the London court is looking at from a distance, the annulment will then not be respected. So they're the kind of headline points on that issue.
So just taking further from what you just mentioned, in case of, let's say, an enforcement proceedings, is it the case that the enforcing court would actually analyze the such order of the seat court which have annulled the award? Is that the position in London?
The argument as to any alleged impropriety would often be made by somebody who was seeking to oppose the enforcement. In certain circumstances, the court, of course, could of its own volition say, well, hang on a minute, there's just something about this that just doesn't add up. And therefore, in terms of the integrity of the system in the jurisdiction where the court is asked to enforce, the foreign award. But in general, obviously, in an increasing cosmopolitan world, there will be assets all over the world. So there would normally be somebody who's opposing the enforcement. So it would not normally be a mere academic exercise. Otherwise, the court could say that it shouldn't have to deal with that. So there's normally assets in the jurisdiction where the foreign award is sought to be enforced, and somebody opposing that enforcement to protect their assets would raise those suggestions that there has been some departure from the normal principles of natural justice or honesty, or the applicable domestic public policy in the jurisdiction where enforcement is sought.
Thank you. And Anthony, what's the position from Singapore's perspective on this issue?
Sure. I mean, this is actually quite a technical subject, so I just wanted to make sure that the audience is following us. So the question here is, what happens when an award, which has been issued by a tribunal in a particular country, let's say Singapore, the seat is Singapore. What happens when the award is set aside in Singapore? Can you still enforce that award in India, in France, in Hong Kong, elsewhere? Now, generally speaking, there are two sort of lines of thought on this. The first line of thought is the so-called, I guess, domestic linked theory, whereby the courts say that, well, an arbitral award is linked to a particular country. And if you set aside that award in that country, you can't enforce it anywhere else, because it's sort of like a judgment which has been overturned, on appeal. So there's no longer a judgment to enforce in other countries. Now, the second sort of line of theory, or sort of line of case law on this, is the so-called transnational theory of arbitration, which means that once an award has been issued, it exists in the atmosphere transnationally. So even if the award is set aside in that country, in Singapore, you can still enforce it in lots of other countries, in again, India, Hong Kong, wherever. So Singapore falls very much into the former category, whereby if an award is set aside at its seat, it probably can't be enforced in Singapore. So there's a 2013 decision from the Court of Appeal where Chief Justice Sundaresh Menon said in obiter dicta that he thinks it would be very, very unlikely that it would be enforced here, which, when the Chief Justice kind of gives you the hint that it's not going to be enforced, that kind of gives you your answer. So Singapore is very much in the former category, whereby if the award is set aside at the seat, you're not going to be able to enforce it here.
Thank you, Anthony. This is by what are the views? I mean, what is the position in India? I mean, from the court on this issue of the arbitration award being set aside in a seat, and then if it comes to India for enforcement, how does the court's view here?
Yeah, in fact, I argued exactly the same point before Justice Nariman in Supreme Court in the case of Betamax, where our client had an award in the favor from Mauritius seated arbitration. There was a challenge filed before the Mauritian court, and India had no connection. Its only thing is that the respondent who lost the arbitration was sourcing the oil from Mangalore refinery. So we went to the Bangalore High Court, Karnataka High Court, and got an injunction against the ship leaving from India, because India has a jurisdiction because the ship was coming and it was attached after the ship was loaded. So that was a big issue, because it was like a big issue between Mauritius and India, because their argument was that the Mauritians fuel is dependent on this ship, because the Mauritius is a very small country, and they said this is the only source of fuel they have for running their vehicles in Mauritius. And they immediately went to Supreme Court. And by the time the order was challenged before Supreme Court by the respondent, quite surprisingly, Mauritius court set aside the award. And this was like overnight, like we never expected that the award would get set aside. So it was a unique question before Supreme Court, is that when the award on which the Karnataka High Court had granted relief of arresting the ship and it was a conditional order that if you deposit the money, you can take the ship away, but if you don't deposit the money, the ship remains in India. And Supreme Court then said that they told Supreme Court that last night the award has been set aside by Mauritian Supreme Court and you don't have jurisdiction. We argued a very same point, saying that look at section 48(1)(e). Section 48(1)(e) copies Article 5(1)(e) of the New York Convention. And it says that the enforcement of a foreign award may be refused if the award is set aside. So the word used is may. So we have copied New York Convention, and the word may indicates that it's not binding on Indian courts to recognize the Mauritian Supreme Court order setting aside the award. And we also told the timing. You see, there was no order. The hearing was concluded 6 months back, and suddenly we get an order moment the Karnataka High Court is passing this injunction. So we argued that, but Justice Nariman said that look, ultimately you have a security in terms of money. You can get it from other jurisdiction also. Let the and Ministry of External Affairs also intervened and said that we have pressure from Mauritian government and all that. So it led to a completely different direction. But this issue came very close to be decided by Supreme Court, and we didn't have the decision on that. But we have filed review, and the review is pending. So we didn't allow the matter to just lapse. And this is the one of the cases where review in chamber got allowed, and it is now listed before the main court to be argued. In Supreme Court, the review is decided in chambers by the judges, and 99.99% is rejected. So this is one of those cases where the review got allowed and it got listed, because I'm sure this issue needs to be decided by Indian court. But I'm very confident there is no judgment in India. Of course, there are judgments in France and in US where they have enforced the awards which are set aside by the law of the seat. And that also brings us to the first question you asked, is how do you select the seat? You select the seat where you don't fear that the court at the seat will set aside the award, which will then take away your transnational character of your award. So that is one of the reasons which you should keep it in mind, that where would you like to enforce the award, and whether the court at the enforcement would be concerned about setting aside of the award by the seat of the arbiter.
Thank you, Tejas. And so we look forward to a landmark judgment to come, at least from the Indian perspective on this.
And Justice Nariman may retire by August.
And I mean, that could be even helpful for other jurisdictions to understand the reasoning which the court would give on deciding this issue.
Yeah.
Okay, let's move forward. Coming to the current pandemic situation, though it has been eased out to a certain extent in many parts of the world, including India, UK, and Singapore. But this pandemic has, of course, given us a good amount of learning in all aspects of our personal, professional life, and including in arbitration. Now, majority of the arbitrations have moved online. Yeah. So what are your views, if I can ask Aaron to start with, on online arbitration? I mean, do you think that this is the future, or if yes, then whether it's going good, or you think there are some more further changes been required, or what are your views on this?
I imagine whenever the world returns to a degree of normality, that where a dispute is below a certain value, there will be considerable pressure in many instances to deal with that online as much as is possible. So many lawyers and many arbitrators will, to some degree, miss the opportunity to be in a hearing room and to have a better sense of the weight they can apply to the evidence they're hearing, or the examination or cross-examination they're conducting. So obviously looking at somebody for hours on end who resembles a postage stamp, it's hard to judge them in the way you could do in a hearing room. So a return to the old order to some degree, but I come down on the pragmatic view that in certain instances the time and the cost of people flying around the world to meet up in a hearing room, or people in a domestic arbitration driving or flying within that territory, in some instances that will just be looked to be abolished, to go away. And so exactly at what stage in arbitration is important but not important enough to be held physically, I don't know. We'll have to await developments.
Thank you, Aaron. Anthony, what are your take on this from Singapore perspective? How well online arbitration have worked during this pandemic, and do you think that it's going to work also in future, especially when Singapore has such robust institution like SIAC, and how SIAC has adapted to this?
Sure. So, I mean, I would start off by saying that I think that over the last year and a half, pretty much the entire world has adapted to doing things online. I actually worked with Samir on a panel together. We worked together on a panel. I've never met Samir in person, but I feel I know him very well. I can judge his professional abilities very well just through working through Zoom. But when it comes to actual hearings as well, of course, I've seen virtual hearings, and there is something to be said for them. They can be conducted well like this. We have 170 participants here, and during the course of last year, I was helping a Vismoot team, where one of the questions was, well, are virtual hearings a good replacement for online hearings? And a lot of the literature out there says that actually, yes, they're great replacements. Everything can be done just as well as online as in person. There aren't that many people who say, actually, no, it's better in person. My personal take is that a lot of people like to say that it's better online, because that's sort of like the cool approach to take, right? If you're like a slightly more senior arbitrator, you want to be seen to be quite progressive. It doesn't really. It's easy to publish something which says, yes, online arbitration is great. You're seen as going in that sort of progressive direction, as opposed to being someone who says, actually, no, I like doing things the old-fashioned way, in person, with physical documents in front of me, seeing the person face to face. My personal preference is actually this old school approach. I find that when you're doing things like submissions, when you're talking just to the camera like this, it's fine. The issue comes in more for me where you have cross-examination, or more sort of like quick fire discussion between two individuals. And again, as Aaron was saying, if somebody is just a postage stamp, it's a little bit hard to have that intensity of debate. And sometimes there are technical problems, which mean that it's just for me at least not quite the same doing it in front of a screen rather than doing it face to face with somebody. And of course, there are lots of other smaller technical issues like, well, is there somebody else in the room with that person? And there have been instances I've seen where there actually is, like literally holding up placards with the answers, like, going next question, next question. These can be mitigated to some extent, by showing your computer around the room and whatever. But ultimately, for me, there's no real replacement for a real live in-person hearing.
So do you think that a hybrid model can work?
I think so. Again, it depends on the facts of the case, as Aaron was saying. There are some cases where you don't need to do intensive cross-examination. Maybe if you're discussing points of law, then these can be debated quite easily over a Zoom call, as opposed to where you have lots of flicking through of documents, lots of, again, in-person cross-examination. The more sort of, I think, quick-fire discussion there is in a case, the harder I think it is to do it successfully over Zoom. Again, possible, but not as successful in my opinion. So maybe for a case where it's a more technical case where things turn on the law perhaps a bit more than on the facts, then certainly yes. And of course, there are cost considerations. In some cases, there's no need for all of us to fly to New York tomorrow, right? We can just do it on Zoom, and it costs $50,000, $100,000 less. So I think there's a balance. There's always going to be a balancing act involved between effectiveness, cost, technicality, or all these different things.
Thank you, Anthony. Tejas bhai, if I ask you same question from Indian perspective, but in a little different addition to this, that compared to, England and Singapore, which are two of the most developed jurisdictions so far as arbitration is concerned, are we as a country ready or equipped, and do we have that infrastructure, the manpower, the knowledge of ODR for that matter?
Yes, I have a slightly different view from Anthony here, and having done arbitration online for last 1.5 years in every form. We did procedural hearings, we did the evidence hearing, final hearing, and it was quite successful. And imagine all of us would have been jobless for last 1 year if technology would not have come to our rescue. So we are dependent on this technology today for our livelihood, and otherwise then all our talent would have been gone waste, and we must be only talking on webinar. And imagine the delay, the kind of delay it would have caused for all the matters. So my view is that it's not going to go away that easily. Of course, there would be exceptions, and some cases would require physical hearings, and parties are willing to do so. But I'm pretty sure that some of the parties would insist on online, and the arbitrators would have to decide the issue. The issue was reversed prior to pandemic. I remember I made one application because our main witness had left our claimant's organization and joined some other company in Oman, and he was not getting leave. So we asked the tribunal to have a cross-examination through video conference, and it was rejected. And it says that if he doesn't come, we will say that he's not been presented for cross-examinations. He all the way came. And after that pandemic came and matter was adjourned, and we were hoping that arbitrator would not do anything, but surprisingly, arbitrator sent an email after 6 months that now let us do online hearing. The person who was rejected has now said that let's do online hearing, and we were quite okay with that. So I'm sure that the situation would be reversed when everybody wants to do physical. There would be one party who wants to do online, and unless both parties agree on a certain procedure, or you have an institutional rules which will override this, and we have seen amendments to the institutional rules also which now allow online hearing. Some of the institutions are all going to have online facility only. So if you have agreed to that, then you have agreed to online hearing at the time of entering the arbitration agreement itself. So those are going to be the new shifts towards this, because what people have realized is they are, and especially Indians who are very cost conscious, is to see that they have seen the advantage in terms of the cost, because you are saving a lot of travel costs and the arbitrators travel costs plus their stay and first class business travel and all that. So that has kind of saved in the mindset people are realizing. And in commercial contract, we have seen the documentary evidence plays a major role. You may have this cross-examination, expert evidence and all that. But ultimately the arbitrators rely upon the documents, and then in online also you have live transcript. So of course that intensity and all is good to have, but if you see the cost benefit analysis, online is not same but equally good as compared to the physical hearings, and I feel that this is going to stay even post pandemic time.
Anyway, just asking again, I mean, does India, I mean, as a jurisdiction, are we really equipped, as I ask you, from the knowledge or technological perspective for an effective ODR?
Yes, definitely. We have platforms which are getting developed, and it doesn't matter, because even if Indian institutions are offering online services now, we see MCIA, Nani Palkhiwala Arbitration Center, they are offering online services. So we are fully equipped to handle it. And in terms of the and quite surprisingly, I'm doing a lot of arbitrations before the retired Supreme Court judges, and they are also quite okay now handling online hearings for days together. So I've done 11 to 5 arbitration before 3 former Supreme Court judges, and it went perfectly fine. And they were appreciating, and we could see the body language also, because many times they are on mute, but if they have a question, if you are attentive while arguing, you can see that they have some concern, so you may ask them. So yes, it's not the same, but I would say it's very similar, and I had a very good experience over last 18 years, and I feel we are fully equipped to continue with this.
Thank you, Tejasbhai. Moving further on this, you see, Tejasbhai, just again to you, this is new, the issue of third-party funding, which has now been, quite actively being considered in India. And recently, I think Singapore passed a law of allowing officially third-party funding in domestic arbitration also. So Tejasbhai, what do you think is it actually required, and what are the advantages, and what is actually third-party funding? If just to explain to the newbies here, what we mean by third-party funding and how it happens, what are the advantages, especially from Indian perspective?
Sure. From Indian perspective, we need a clarity on third-party funding, because there is no direct provision which allows it. Like in Hong Kong and Singapore, they have now changed the law. India, we need to have that clarity. We have one judgment of Supreme Court of A.K. Balaji, where the Supreme Court has held as by way of an arbiter that it is not prohibited, and that's true. So that gives some indication about third-party funding. But before that, third-party funding is a tool where a third party who is not a party to the arbitration agreement can fund the claimant, so that once the award comes, the proceeds of the award can be shared between the claimant and the funder. They can have an agreement, third-party funding agreement, where they decide the portion of sharing. If the claimant loses, then the third-party funder loses the funding. There are a lot of issues which come in through third-party funding. Is the concept of champerty and maintenance, which is an old common law principle. But that also now, so long as the lawyer is not involved in funding, so you can't, in India, we can't have a success fees, or we can't fund litigation as lawyers. So that is prohibited. But if it is an independent third-party funder who has funded the arbitration proceedings, the advantage is that I may have a very good claim, but I may not have a liquidity to bring that claim against the respondent. And many times we see Indian parties not having enough funds, are not able to go for arbitration, and they try settling it. But if you have a funder to back up the claim, because that is one thing where you are ensuring that the funder believes in your case. Therefore, and the third party funder also does the independent analysis of your claim. So that gives you also confidence that yes, you have a good case on merits if somebody is ready to fund you. So therefore, it's a good tool which we should have. It would also make Indian arbitration more professional, because the funders would have their own advisors, and they would ensure that the arbitration happens in a more sophisticated way, because they are interested in the outcome and the speedier outcome, because they have already invested in that. So overall, it would help. It's very common in Singapore and London. We have had cases where the enforcement of those awards, which is funded by third-party funders, are now pending before Indian courts, and Indian courts have not objected as such, so long as it was disclosed and confidentiality is maintained, because the third-party funder also will get access to the documents in the arbitration, although it's not a party to the arbitration agreement. So the confidentiality issues arise, but there is also confidentiality agreement which is entered by the third-party funder to maintain confidentiality. So those are the advantage. I see the time, we are running short of time. It's a subject we can go on for half an hour on third-party funding. But in India, I would say it is not expressly permitted, but it's not even prohibited. So if somebody wants to avail a third-party funding, they can do so, but it's not that prevalent. And I feel that if we get a clarity either by way of a judicial pronouncement or a amendment to the law, it would really help to bring India at par on third-party funding scene.
Thank you, JSB. And yes, of course, due to constraint of time, I'll just wrap it up with one last question, which is equally interesting to both you, Aaron, and Anthony. Considering the recent survey which came out about the preferred seats and the race between the institutions, of course, London is first and Singapore is strongly at second. So do you think do you view this as a healthy competition, or it's a US-China kind of an issue? Aaron? Oh, you are muted.
Sorry,
Yes.
I keep muting myself. Can you just go through that one with me again? Sorry.
I'm saying that according to recent survey, London, of course, is the most preferred seat for international arbitration, and Singapore is strongly on at second. So do you think that this is a healthy competition, or it's a US-China kind of a issue?
I mean, sorry, it's a bit pedantic, but I would imagine if you cast your net more widely, there's probably a batch of surveys which agree generally who the top 5 or 6 seats are, but they maybe place them in a different order. So possibly some of us would say that you shouldn't pay too much attention to those surveys. And on a year-by-year basis, one particular city might be number 2 one year and number 3 the next year, so they all move around. So I think obviously anybody promoting a seat tries to have regard to what other seats are doing in terms of what they might need to alter in their own seat. But there's also probably the duality of you need to identify in your own seat how you proceed, and to some degree not to be looking over your shoulder. So I mean, I think the competition is there in the background, but the degree to which everybody pays attention to it and the degree to which it's useful is something that we might all disagree on.
Thank you, Aaron. Anthony, what do you have to say?
Sure, I'll keep this short. I mean, I think that the Western European and North American institutions, especially the Western European institutions, have quite a long lead. You know, they started a lot earlier than the Asian institutions. LTIA, I believe, is about over 100 years old. SIAC is probably younger than I am, and I'm not over 100 years old, right? So they've definitely had that advantage for a long time. I mean, I think that right now, we're for now catering for different markets. Generally speaking, the LTIA is dealing with a lot of Western European type stuff. Right now, SIAC, HKIAC are more focused on Asian-based cases. I don't see it as being a US-China situation where we're actively trying to beat each other in that sense. But of course, as any sort of competing commercial entities, there is some sort of friendly rivalry going on. And who knows, in the future, it would be great from my perspective if SIAC and Singapore sort of keep on rising further up the table. But that's not to say that I would, actively discourage people from approaching Aaron or the LCIA or using London as a seat. So I would definitely call it friendly competition and not like a antagonistic relationship.
All right. Thank you all three of you. Thank you, Tejasbhai, Aaron, and Anthony, for making us go through the systems of 3 different jurisdictions. And I'm sure the participants would be taking back a good amount of knowledge and understanding of these 3 different systems and the issues what we discussed. Thank you so much.
Thank you for the invite. Thank you.
Yeah, thanks
so
much.
We just open up for the Q&A.
Yes, sir. thank you so much to all the panelists for sharing such a great opinions here. So, sir, should I share the questions?
Yeah, please read and just also mention to whom it is being addressed.
Okay. So the very first question is from myself right, only. It's to Tejas sir and Mr. Anthony that India doesn't have any mechanism for enforcement of international orders or judgments in India. And in context of the dispute between Amazon and Future Group, Reliance is also involved in that. The judgment pronounced by SIAC is facing difficulties in enforcement of order in India. What are the views of respective panelists on the same? Also,
I'll go first. So this is an issue which we have two issues. One is that the recognition of emergency arbitrators, because mostly the orders passed by emergency arbitrators come for enforcement. So the only solution we have is that we have to file fresh Section 9 in India to get the interim relief in terms of the orders passed by the emergency arbitrator outside India. So if that is one way to deal with it. And if the seat of arbitration is in India, the judgment which you referred also says that it is the emergency arbitrator is also an arbitrator under Section 17. So now what we have done is that the interim orders passed by the arbitrator are deemed order of the court. So under Section 17(2), the orders passed by the arbitrators are deemed to be an order passed by the court, and therefore you can go for an contempt of the court if one party is not following the interim measures. So if the seat of arbitration is in India and that is the question, then the orders are enforced by the Indian court. The only issue comes in if the seat of arbitration is outside India. In HSBC case, Bombay High Court and number of other cases in Delhi High Court also, we have passed identical relief by the court under Section 9, which is again enforceable. So that is the solution we have found, because what is enforceable under New York Convention is only the final award and not the interim order. So that is the problem. So one way we could have solved this problem is to amend the definition of the tribunal to include emergency arbitrator. And therefore, all the orders passed by the emergency arbitrator could be treated as an order under Section 17. But Delhi High Court in the Amazon Future Justice Midha judgment specifically recognizes that the orders, even though the emergency arbitrator is not recognized by the Act, it is nothing but an arbitral tribunal which is appointed by the parties for the limited purpose of granting interim relief under the institutional rules. So that is the judicial pronouncement which would help us to bring the orders passed by emergency arbitrator also as orders passed by the tribunal under Section 17, which themselves are enforced because they are deemed to be orders of the court.
Yes, please.
Thank you. I think Tejas is infinitely more qualified than I am to talk on this issue. I've talked to one of my friends who's actually working on that case for India. And of course, he's discussed some of the things with me that Tejas just mentioned, but there's nothing I could add on to what Tejas said about the Indian aspect of it. What I would say, however, is that this Amazon case, I think, brings up quite an interesting point, again, about choosing the seat and understanding the global infrastructure, the global arbitration infrastructure when you're doing a case. By that, I mean that there are some instances where you'll want to enforce an interim award or an interim order against the respondent party. Now, if you're thinking ahead, and I'm thinking, especially when you're in the contract drafting stage, if you're thinking ahead about these sorts of issues, you'll know, as Tejas was mentioning, that in certain countries, you just can't enforce an interim order because the New York Convention doesn't necessarily refer to orders, it refers to awards. And so when you're looking to, let's say you have a respondent who is based in Indonesia. Simply put, you can't enforce an interim order against that respondent in Indonesia. What you would have to do is ask the tribunal for an interim award, which grants interim measures or decides an interim question. So again, it's really important when you're starting off an arbitration, before you start it, to really do this very broad analysis to understand who are the parties involved, what are the jurisdictions involved, and how do those different jurisdictions treat these issues. Because again, you might be in a situation whereby you're trying to enforce an emergency arbitrator award in India, and you find out that you're not really sure if it's enforceable or not.
You're very right, Anthony. And I mean, this is why, yesterday, I, in fact, along with another junior colleague of mine, we took that session on importance of drafting an arbitration agreement or a clause. So we made the participant understand what is the importance, how you have to actually, how you should be drafting a proper valid, what are the issues goes into beyond drafting a clause. And that's exactly what you explained today. And I'm sure now they would understand the importance of drafting a proper arbitration clause. Yes, what's the next question?
Yes, so the next question is for Aaron, sir. Okay, so the question is, in 2020, some reforms were proposed by the Law Commission. One of them was codification of Arbitration Act in similar manner to Civil Procedural Code. What are your views and opinions on that?
Sorry, I got the prize amongst the panel for being on mute the most for some reason. I can only plead. It's still early-ish on a Sunday for me. The Law Reform Commission has suggested it needs to look at the Arbitration Act in the past, and that's not gone anywhere. So by the nature of a Law Reform Commission, it produces more ideas than are actually implemented. So the deficiencies in the Act were pointed out in Halliburton, in that it doesn't deal with absolutely everything. So regardless of anybody's view on that issue as to the utility of having a complete code of arbitration, the second issue is, at what point might that happen, allowing for the demands and pressures on the Law Reform Commission's recommendations, to be implemented. So it's not something that I'm especially passionate over one way or the other, which is probably not helpful, but there you go. If it happens, it happens. If it doesn't happen, that reflects the past history of the Law Reform Commission's examination of arbitration. It's not always made the cut of what is put into place, what is changed.
Thank you, sir. I hope the question is well answered. Thank you. There's one more question, but I think it's been already discussed in the session. And due to the constraint of time, I request all the panelists to take other questions offline. Is it?
I'm happy to do that. I've put my email in the chat box for anybody who wants it.
Okay,
yeah, sure. Likewise.
Thank you so much, sir. All the questions which are unanswered during this session would be answered offline from the panelists. So thank you so much. Okay. Thank you so much to all the panelists. We are honored to hear all the respective opinions of you in 3 different jurisdictions. So moving forward, we are highly honored to have all the esteemed panelists joined us today. We are more thankful of Mr. Samir Shah, sir, to moderate this discussion. Thank you so much for all the panelists for sharing all the valuable insights in the discussion that has taken place today. Now, now to deliver the concluding remarks and for vote of thanks, I would like to welcome our HOD, Dr. Namita Jain, ma'am. Ma'am, over to you, ma'am.
Thank you, Shivani. Thank you to all the panelists. Are you showing e-mementos, Shivani?
I request Akshay to present the e-mementos.
Yes, please.
Thank you
Yes,
so
please.
much, Aaron sir, for accepting our invitation to be a panelist in National Bootcamp. Please accept this e-memento as a token of gratitude from Faculty of Law and Amicus Curie. Thank you so much, sir.
Thank you very much. Thank you.
Good afternoon, Tejas sir. Thank you so much for accepting our request to be a panelist in this bootcamp, which is full of knowledge on arbitration. Please accept this e-memento as a token of gratitude and respect from Faculty of Law and Amicus Curie Club. Thank you so much, sir.
Thank you, Dr. Jain. Thank you so much. It was my pleasure.
Good afternoon, Anthony, sir.
Good afternoon, Dr. Jain. Very well, thank you.
Thank you so much, sir, for accepting our request. Please accept this e-memento as a token of gratitude from the family of law from JCRC University and Amicus Curie Club. Thank you so much.
Thanks again, Dr. Jain, and congratulations to JU for becoming such a reputable university so quickly. I've heard that it's a fairly young faculty, so you guys have done a great job. Thanks.
Thank you, sir. Thank you. But this is not possible without all of you. So thank you so much for accepting our request.
Thank you.
Thank you, Sami, sir, for moderating this session, for directing us, for each and every support at every moment of time. Thank you so much for making this event successful. Without your guidance, I think this event is not possible. Thank you so much, Sami, sir.
Ma'am, it's my pleasure. And in fact, I mean, the students and the faculties have equally worked hard. So they are also, I mean, equally to be congratulated and appreciated for their hard work. And I'm sure this event will be a learning process for the future further events to come. Thank you so much.
Thank you so much, sir. Thank you so much to all of you.
Thank you so once again to all the panelists. Thank you all the participants for being so kind and patient till 12 o'clock. It's been 4 hours straight. They all are being patient and joined with us from straight 4 hours. Thank you so much to the whole team of National Bootcamp, faculties, HOD ma'am, and everyone who is here in the meeting. Let's move forward for the last session. We'll meet you at 4 for the next session. Till then, we have a break of 40 minutes. We'll see you.
Thank you, Anthony. Thank you, Aaron. Thank you.
Thanks, guys.
Bye. Thank you, everyone. Thank you, Aaron. Thank you, Anthony. Thank you, Tejas sir.